Hey, this is Politics with Laura here. How you doing? Day 2 of the Fani Willis trial. Oh, well, I'm sorry, not day 2. I'm finishing up on day 2. Day 1, I'm sorry. Day 1. Sorry about that. Oh, this is something. This is something. This is something. I will say this. Oh, I forgot to do this. I will say this. There's a lot coming out within this trial, and I most definitely have to say I find it a little interesting how Trump's lawyers are going after, in my opinion, the character of the people. Fani Willis, goodness, we'll get to that, but I meant to do Terrence Bradley. So let's go ahead and get to him. I did. Forgive me. Forgive me. Let me see. Okay. Okay, here we go. All right. Okay, they're going to bring him in. He should be in by now. Let me see.
Question to allow counsel the opportunity to object.
Sorry about that. Terrence Bradley.
Why does that need to be in camera?
Doesn't necessarily, well, there's statements that could be made that could be prejudicial depending on whether they were covered or not, whether he's going to break the...
So at the time a question is asked that you think implicates some of those statements, object, and we'll handle it.
Thank you, Judge.
On behalf of Mr. Bradley, and I apologize, this is not our proceeding, but it might be helpful to have a brief sidebar
as opposed to something in chambers, at least so that we could let the court know our position rather than having to restate it repeatedly.
And Judge, I've carefully crafted my questions to avoid any privileged information, but if they think that I'm invading that, then I welcome an objection, and I'm happy to address it.
Let's see how it goes. And again, Mr. Bradley.
I'll ask if you can just give a pause in between each question to allow counsel the opportunity to object before answering.
Thank you, Judge. Was the witness sworn, or do I need to swear the witness?
I believe he was.
Great, thank you. I'm sorry. Good morning, Mr. Bradley. How are you?
Good morning.
Not happy to be here, I'm assuming.
I am not.
Okay, I understand. Thank you for being here.
Wasn't by choice.
Right. So you were subpoenaed to come and testify in this case.
I was.
Okay. But you and I have spoken previously about relevant facts surrounding Mr. Wade and Ms. Willis's relationship.
No, we have not.
We have not. We have not texted about those facts?
Through a third party, you were given some information. You and I shared text. Our texts were more so about my health, more so about if I was okay with what was going on, that I would not be, whether or not I was going to be subpoenaed or not, and that emphatically I would not have been sitting in this position as being called as a witness. So that's what my text chain show. So no.
That we've never talked about Willis and Wade having a relationship.
Not directly you and I, no. We talked about my health.
Okay.
We talked about, as I stated before, other things, but not this, no.
Okay. Did you text me about Wade and Willis taking many trips together?
I object. Well,
Mr. Brown, there's been an objection.
One, I'm going to object as it relates to attorney-client privilege. Two, I'm going to object because I haven't seen the text message that she's attempting to impeach the witness with. And two, he's made
Now, what you're going to see is a lot of questions about Fani and, oh my goodness, Fani and Nathan's relationship, and they're trying to tie that into the money so that they can say, okay, she's disqualified. So you're going to see a lot of that. Now, some people may say, well, that right there isn't relevant. And in its face, it's not. But however, if you want to take the money that was given by the people and Fani giving him the job and then him spending the money on her in their romantic relationship, or however you want to do it, they're trying to make those connections. Okay, I just want to make sure that that right there was understood.
Asked about, and that the only information that she has from him is the third party, which would be hearsay.
Ms. Merchant.
Judge, it's not hearsay. We've had these conversations. If I need to take the stand, I will. If I need to put my phone into evidence, I will.
Ooh. Ooh.
So the first objection was to privilege on behalf of the state.
Oh, I'm sorry, I did not respond to that.
Sure.
Thank you, Judge. Privilege is only communications that are made in furtherance of legal advice. There's been no showing that whether or not they took a trip to California or took a trip, or that Mr. Bradley and I talked about that, either in person or by text, that's privilege. I'm not asking for any communications that Mr. Wade might have made to Mr. Bradley in furtherance of any legal advice.
All right, and Mr. Abadi, I believe as the one asserting privilege, it would be your burden to show the necessary foundation there. Is that something you want to voir dire the witness on, or take up here on this specific question?
Well, no, I'd also object to foundation grounds. She has not provided any foundation that he would have any knowledge of what she's requesting he answer. His answers were he had no knowledge, and now she hasn't laid the foundation in order to continue to ask the same question over and over.
Ms. Merchant.
Judge, on behalf of Mr. Bradley, we do object. This falls under the privileges afforded under 1.6 of the rules. And the attorney-client privilege is not something that Mr. Bradley can waive. Only Mr. Wade can waive it, regardless of any information or communications being proffered by the client. Mr. Wade would have to waive them in order for Mr. Bradley to continue to testify about any of this relationship until it's been established when that privilege should have begun.
Sure. And so far, though, I haven't heard anything about a relationship, about an attorney-client relationship, about a privilege ever attaching. And I think that's going to need to be established before we can actually determine the scope of it and whether this falls inside or out of it. So I think either Ms. Merchant can take the lead if she wants to, but my understanding was that generally has to fall on the person who's asserting the privilege.
She's messing up.
Except
She's putting the horse before the cart.
Authorized to violate that privilege,
Cart.
or else he has in fact violated the bar rules, which we have an opinion regarding from someone in the state bar of Georgia.
All right.
That's why I thought perhaps a sidebar might be important rather than my interjecting.
Well, I still want to kind of see how we can go. So, Ms. Merchant, it sounds like you're going to need to lay a little bit more foundation to see whether this actually is going to fall under privilege or not.
That's not a problem, Judge. And what I can do, I was just told that Ms. Yerdey's in the waiting room.
Miss Merchant, the lawyer, she's messing up, in my opinion, because she's basically putting the cart before the horse. She's trying to say, okay, this occurred without establishing a foundation to where she can say, well, I have this. But let me go back to the trial. I'm sorry.
Room, but I can, if the state wants to read my text, if Mr. Bradley wants to read them to refresh his memory, I have absolutely no problem with that. I have my phone here, and they're welcome to do that. But I'll talk about some other things, and then maybe if they're going to have a lot of objections to privilege and hearsay, what I can do is I can lay a foundation with Mr. Bradley, get him off the stand, put Ms. Yerdey up, and then Mr. Wade, so we can get through the privilege issues. That might make the most sense. Thank you. All right, let's talk about something not controversial then. When did you and Mr. Wade first meet?
Probably 1998.
Okay. And did you all have a law firm together?
We did.
Okay. When did that firm start?
Probably, I think it was 2010. We started exclusively working together as a firm, operating as a firm.
Okay. And were you all actually incorporated as a firm?
Not initially, no. He had, when I passed the bar and I hung with Shingle in '07, I think he had been practicing a few years prior to that. He had his own firm. We had two separate firms.
Okay. At some point, did you all incorporate, though, together?
We did.
Okay. Do you remember about when that was?
I do not at this particular moment, no, ma'am. I'm sorry.
Okay. Do you remember if it was administratively dissolved?
I've been made aware that it's been administratively dissolved. Yes, I left the firm around 2 years ago.
When did you leave the firm?
August of 2022, I think it was.
August of 2022. Okay.
Or it was either August or September of 2022.
Okay. August, September. Let me make a note. So in October 2019, were you all incorporated as a firm?
I think we were, maybe.
Okay.
Yes.
And when Mr. Wade filed for divorce November 1st or 2nd, 2021, were you all incorporated as a firm?
We should have been. I'm thinking that we were. Yes, ma'am.
Okay. When did Mr. Wade come to you to file the divorce action in Cobb County?
No, that's privileged information.
The timing and the beginning of the privilege, I don't believe that is overruled.
So the timing was around 2018.
Okay.
And it was probably December of 2018. I remember it specifically because I was building a house, and I noticed that he wasn't wearing his ring. I asked him about it. I had invited him to the house because I was having not a housewarming, but people over. And he wasn't wearing his ring. I inquired about it. From there, we discussed what would happen. And we discussed the divorce and what would happen.
What would happen with the divorce?
What would happen over me representing him for the divorce and when he would want to do it, yes.
When did he retain you?
Well, my memory would be 2018
okay.
when he consulted with me about the divorce and told me what he would like to see done and when he wanted to do it.
Do you know when Fani Willis and Nathan Wade met?
Specific dates, no. I know it was sometime at a conference.
Municipal court conference?
Correct.
Okay. And October 2019, if it's been represented in the state's pleadings before that's when they met, does that sound familiar?
If that's what they're saying, then absolutely. I know it was at a conference in 2000. I mean, it was at a conference. If you say it's 2019, I'll take you at your word.
Okay. So it was what you're sure of, though, is it was at a municipal courts judges conference.
Yes.
When they were both municipal court judges.
Yes.
So it's fair to say, since she became the district attorney, she was no longer a municipal court judge. So it had to have been before that.
That they met?
Yes.
Yes.
And he was teaching a class at that seminar, as far as you know?
I'm going to object this to leading at this point. She has no direct.
Was he teaching a class at this seminar?
To my knowledge, he was.
And was Miss Willis, to your knowledge, attending this seminar?
Your Honor, I'm going to object. He has no personal knowledge. He wasn't present at the municipal court training.
Judge, they put it in their pleadings. Like, we are going to be here all day.
We are going to be here all day.
All right. If you can establish that he would have some personal knowledge, then that's a fair question. So if you just need to preface it with that, then that's fine.
Thank you. Are you aware of when their romantic relationship began?
Your Honor, I'm going to object. That relates to privilege. She says that he began representing Mr. Wade in 2018. He met Ms. Willis in 2019. That's clearly within the bounds of attorney-client privilege.
I think there's understood, Mr. Abadi. So I think, Ms. Merchant, you need to qualify that question.
Thank you. I'm not asking you to tell me what Nathan Wade told you in furtherance of legal advice. Okay, so I want to be very clear. If he told you something asking you legal advice, I'm not asking you about that. I'm asking about what you observed, what you saw, and what you knew outside of what he told you when he was specifically seeking legal advice. Okay?
This is too far afield. I apologize. I object again on behalf of Mr. Bradley. He's asserting that there is an attorney-client privilege associated with this case under Rule 1.6. For him to draw any inference, make any statements, or any other proffer of information after this relationship began between attorney and client in December of 2018 would be improper, and he would in fact be violating the rules of ethics associated with his bar license.
So the way the question was phrased was just saying, what did he personally observe outside of the relationship, not involving communications? How does that fall within attorney-client privilege?
Your Honor, whether we like it or not, when we have a client, there are a number of items associated with that relationship between attorney and client that come within your purview and that lead you to further action, lead you to further investigation, further questions, develops your strategy. We can't talk about Mr. Wade on any level. It would be inappropriate. The divorce was filed sometime thereafter. During that entire interlude, any of these issues could in fact have formed the basis for their relationship to remain privileged.
Ms. Merchant?
Judge, his observations are not privileged. That's not what the privilege law says. And I can read you the attorney-client privilege attaches where, and this is the law, this is the rule. There's an attorney-client relationship. The communications in question relate to the matters on which legal advice was sought. And the communications have been maintained in confidence, and there's no exceptions to the privilege. First, or number two, the second prong. This was not in furtherance of legal advice. That's not in furtherance of legal advice. What he witnesses as a human being is not in furtherance of legal advice. Unless, I mean, and if he witnesses them together, it would get rid of the attorney-client privilege because Ms. Willis is there. Additionally, though, exceptions. We can go all day about exceptions to this. Fraud to the court, that's an exception. Mr. Wade, we contend, has filed a false affidavit with this court. That is fraud to the court. If this witness has direct knowledge that that is not true, then that's an exception to attorney-client privilege.
Okay.
All right. Ms. Merchant, if you could re-ask that question, again, qualifying it as, if it's, I think you qualified it as anything that, outside of anything he learned or was told as a result of his representation. It was just any observations he made, which, in my mind, as you phrased the question, would have included before December 2018 when this first consultation occurred. I think if you can go step by step, we can handle this.
And Judge, I would just ask permission. We gave the state notice under 611 that all of these witnesses do not want to be here. They are adverse witnesses.
I understand.
Yes, so I'd like to have leeway to be able to cross them. Thank you, Judge.
Look at his stare.
All right, Mr. Bradley.
Yes, ma'am.
You have knowledge that their relationship began in 2019.
I do not have knowledge, but again, I have consulted with the bar as late as yesterday at 4 o'clock. I am not here to...
Your testimony is that you do not have independent knowledge.
I cannot... I was advised by the bar that Rule 1.6 of confidentiality applies and that I cannot reveal anything that I saw or learned. And that if the court is asking me to do that, that an immediate certificate of review should be asked.
Oh.
And so I'm not here to misrepresent to the court or to say anything inappropriate or anything. I am here because I also have a law license. And I'm not trying to lose that.
And so, Mr. Bradley, can you finish that thought? As saw or learned, just period, without qualification whatsoever?
Judge, I'm going to refer to what I was told by the bar, that Rule 1.6 of confidentiality applies, and that I would be asking for an immediate review by the Supreme Court.
Sure, but applies to what?
Any communications.
Oh, snap. So, if he answers anything, the Georgia law bar is saying, hey, Mr. Bradley, if you answer any of those questions that relate to Mr. Nathan Wade, and you're representing him, if you answer any of those questions while you're in court, we're going to snatch your license. When the prosecutor said that that there were certain qualifications for attorney-client privilege, so she gave those, but the Bar Association said something different. I find that very, very, very interesting. Oh, man. Let me put myself over here.
Is what the person at the bar told us.
Any communications? Feel like
He did not
if you
qualify.
talk to Mr. Wade, that's covered.
Well, Judge, I don't know. He didn't go into those specifics, but this is what was told. I was sitting there with my attorneys, and this was what was told to us. To state that Rule 1.6 applies, and we gave them the scenario, and this is what they told us to do, and this is what I'm doing at this particular point.
Judge, and we have no knowledge if the bar was aware of the affidavit that Mr. Wade filed, but that significantly changes the privilege. He waived the privilege when he put that in the affidavit, so that's one of the reasons I wanted to call him. That's a waiver. He put the relationship in the when the relationship started, and put the relationship in his affidavit. He put a lot of information in that affidavit that would waive certain amounts of privilege. So he disclosed this relationship. So basically what we've got is we've got Mr. Wade being able to say what he wants about this relationship, but then we're not allowed to ask questions to qualify that. So that's not how it works. They either get to admit it or they don't. Either privileged or it's not.
We're just talking about a relationship, though. How does that open the floodgates to anything he's ever told an attorney during representation?
It doesn't, and I'm not asking him that. I'm asking for his knowledge. They were law partners, and as I go through the questions, I think he has knowledge of things that is not something that Mr. Wade specifically told him. I also think there's a fraud exception to a lot of this, even if there was a privilege, but I don't think there was for most of it.
Your Honor, but he's already represented that he has no knowledge.
She's saying what she
I don't think
thinks.
we've actually gotten anything to that extent yet. I think we're still making our way through it, which is, I think he's taking the position that he's not willing to share anything Mr. Wade ever told him, period. Which that's a broader representation of attorney-client privilege than I've ever heard. And I think that's what we're trying to parse out, is if the relationship starts, I've never heard anything that said everything before that point is privileged. Do you have something that I should know? Yes, sir. That's fine.
Before that relationship, these questions weren't being established. It was 2018, December. The last question was directly related to a point in time after that, during which the relationship between me and client would have been already established. He has an opinion from the State Bar of Georgia. If he's going to be required to testify, he would be ordered by the court on any of these issues. And Judge, I understand how delicate this is. You can phrase it in 1,000 different ways to try to make him say something, but you can't unring a bell that he puts out into the universe where he has violated that privilege. We're going to get to go back 6 months from now and say, oh, well, we shouldn't have said that. It's not acceptable. It violates hundreds of thousands of relationships in this state that we rely on in order for the justice system to function. This is an attorney-client privilege issue. We've done all the diligence we can as far as looking up the relevant laws, the relevant information. We do not have a waiver from the client. So the client is present. Well,
There's no question why we're not barreling ahead is because I recognize the privilege. What we have to determine is
Actually, what that privilege, the scope of it, and when it started, and I don't think we've even gotten close to that yet.
I apologize, Judge. I thought December 2018, Mr. Bradley testified directly that is when the retainer and the divorce proceedings were beginning. The issues then brought up by the state have to do potentially, if I've been...
So we have a starting point,
Right.
but does that necessarily foreclose anything from that point onward? If they started talking about something else entirely?
Post-divorce, of course not, Your Honor. But during the pendency, it would absolutely curtail that, especially as it has to do with observations, attendance at functions together, or other realizations that Mr. Bradley came into during the pendency of his representation. And to parse it out would put Mr. Bradley in an untenable position because his reputation means everything.
Okay, Mr. Sadow.
No, I think we're talking about two aspects of arguably the attorney-client privilege. There's the attorney-client privilege, which is controlled by case law and statute, which deals with communications and arguments. I don't hear that being the objection. The objection is that there are confidential matters under 1.6, which in some form or fashion mean that once you start a relationship with attorney-client, that everything from that point on is confidential between the two of them. There's no such case law in Georgia that deals with confidential information at that time. Attorney-client, yes. Confidential information, no. And I believe what's being argued by counsel, Mr. Bradley, is that he has received, of course, we don't have anything in writing, but he's received some oral advice that under 1.6, confidential matters cannot be gone into, which is, according to them, everything that occurs between Mr. Bradley and Mr. Wade from 2018 forward. There's no such law that protects such confidential, only communications made in person. And if I'm mistaken, I apologize, but I think what we're being told is I don't have to say anything at all about Mr. Wade once I have an attorney-client relationship with him, because it would be deemed confidential, and if it's deemed confidential, I can't talk about it. And there's no such case law to that effect in Georgia. There is no bar rule to that effect. The only thing the court has to do is say, are we talking about attorney-client privilege or pure confidences or confidential information? And once you decide it's confidential information, you order Mr. Bradley to testify, and then it's up to his counsel to decide whether he wants to have his client held in contempt after you've ordered him to testify.
And Judge,
that's an overstatement. We have not said that he can't testify to anything. The specific question on the table is, what observations do you have from Mr. Wade and Ms. Willis from that point on? Now, they, the defense and their teams, have made an allegation of some impropriety. That same impropriety could be related to a divorce proceeding on every level. We're not here to say we're not talking. We're here to say we're not talking about things that came into his knowledge associated with his representation during the divorce. I realize there's an evidentiary standard, and then I realize that there's the cornerstone of what we do, which is the bar rule, the state bar rule 1.6. We violate that, and the whole thing comes tumbling down. I'm not saying that you can't ask about, did Mr. Wade enjoy a beer at a ball game? That wasn't the question. The question was specifically relating to some impropriety that they are trying to dig into. That is privileged information.
And more importantly, Mr. Bradley has said twice now that he has no independent knowledge as it relates to what she's referencing. He has said it 2 times. So there's not a good faith basis for her to continue to probe into this area, because he says he has no independent knowledge outside of the attorney-client privilege.
All right, Ms. Merchant, last word.
yes, Judge. Judge, Mr. Bradley, if ordered, he's here by subpoena. If ordered to testify, it's not a issue with the bar. My question was not about attorney-client privilege. I'm being very careful not to ask anything that Mr. Wade asked in furtherance, but I've been informed that Robin Yerdey is on the Zoom, and so if we want to start back on our original plan, we can call Ms. Yerdey and have her testify, and then put Mr. Wade up, and we can go through the privilege issue with him, and then we won't have to have all these objections. Or else I'm happy to continue questioning Mr. Bradley.
All right, so Ms. Merchant, you're saying that your understanding of the evidence that you plan to present, that these issues are affected by Ms. Yerdey in terms of the scope of the privilege and the relationship?
No, I think, no, thank you for letting me clarify that. I think that Ms. Yerdey is going to give me enough to get Mr. Wade on the stand. Once I get Mr. Wade on the stand, because they filed a motion to quash, and you said I had to present something before I could put Mr. Wade on the stand. So once I present Ms. Yerdey, I can put Mr. Wade up on the stand. And then I can put him up before I call Mr. Bradley. And then I may not even have to call Mr. Bradley at that point.
All right.
Judge Matt.
Sorry, who's
I'm on Zoom, Your Honor. Attorney Durante Partridge, Judge, on behalf of Ms. Yerdey. Your Honor, when we were here for the motion to quash earlier this week, it's my understanding, as represented by defense counsel, that Mr. Bradley's testimony is, so to speak, the bridge that was built to involve my client, Ms. Yerdey, into this matter altogether. Now it seems as though that is being usurped, and now she is being the quote-unquote foundation for defense counsel's presentation this morning. So we do object to that, Judge, and would renew our motion to quash the subpoena, because this is completely contradictory to what we had via the hearing earlier this week, Your Honor.
Judge, may I respond?
It's okay, Ms. Merchant. Mr. Partridge, as I recall, that did not apply to your client as much. The original motion to quash that you filed said she had absolutely no knowledge about anything. What Ms. Merchant proffered, and what I didn't hear you saying was not the case, is that at some point Ms. Yerdey lived in a residence and shared a residence with Ms. Willis and potentially Mr. Wade at some point. So I think she's directly involved in the center of this. I don't think that really needs much in the way of foundation.
And Judge, I apologize, Your Honor, to talk over the court. That information, however, Your Honor, is my understanding came from Mr. Bradley, and that information was incorrect, as I informed the court earlier this week as well. There was never any time that Ms. Yerdey and Ms. Willis lived together. There was a sublet of a condo that Ms. Willis resided in that had absolutely nothing to do with that of Ms. Yerdey, outside of Ms. Yerdey subletting it to Ms. Willis. Ms. Yerdey actually moved into a different residence. Per our conversation with Ms. Merchant yesterday, that is exactly what it is. So there was no overlapping or any time that they stayed together, nor does Ms. Yerdey have any information as it relates to Mr. Wade staying at that condo as well with that of Ms. Willis. So again, Judge, I'm renewing.
No, we don't need to hear it again. Ms. Merchant.
Judge, luckily I don't have to tell the state or them everything that I plan on introducing a witness for in response to their motion to quash. She has a lot of personal knowledge. And when we had a motion to quash, I had to get over a good faith basis, and I presented that to the court. I did not spend 4 hours going through everything that this woman's going to testify to. She has personal knowledge.
Is she actually here?
I think she's on Zoom. What I understand, Mr. Partridge.
Mr. Partridge, is your client with us?
She's on the Zoom platform, Your Honor, since I'm in Richmond County via my conflict. But she is on the Zoom platform at this time, Your Honor, in the waiting room. I believe she may have been admitted. I see a Robin on my screen. I'm assuming that is my client, Ms. Yerdey.
Ms. Merchant, you want to examine her by Zoom?
That's fine.
All right.
We will waive
Mr.
any
Abadi.
Sixth Amendment objections to it. That's fine.
My only objection was the representation at Monday's hearing was the good faith basis was based on what she learned from Terrence Bradley. And we know that is false. It's not true. So there is no good faith basis, and we would renew our objection and to quash the subpoena.
That was not in regards to Ms. Yerdey.
It certainly was. It was at like the 20-minute mark in the hearing.
Judge, she has personal knowledge of this relationship.
It's not what was represented on Monday. The personal knowledge came from Mr. Bradley. She has no good faith basis to explore this fishing expedition as it relates to Ms. Yerdey. This is a blatant misuse of the process.
Ms. jump out of her skin.
I do believe that when we went through the motion to quash, you grouped them into two categories, and each one of them we said that they were going to be impeached by Mr. Bradley.
We took Ms. Yerdey outside of Fulton County, Judge. So we talked about Fulton County differently than Ms. Yerdey. We took Ms. Yerdey out separately. She was different than Fulton County because there wasn't other issues. And again, so we're arguing a motion to quash. I responded to their argument on the motion to quash. Did I tell them that she's going to testify that she's known Miss Willis for years and that her middle name is Latrice? No, I didn't tell them everything she's going to testify to. I don't, if you wanted me to, I could have, but that has nothing to do. There is a witness that contradicts what they have said in court, and they're doing everything they can to keep her off the stand and keep the truth away from this court. They filed a motion to quash. I showed a good faith basis. If my good faith basis is Mr. Bradley or Miss Yerdey or texts I've seen, it's still a good faith basis. There's no law that says I have to tell them every single good faith basis I have ahead of time. If we did, we would never have trials.
All right, Ms. Merchant. Appreciate the argument of counsel. I think the standard on a motion to quash and a subpoena is not one where we're required to completely flush out and litigate every reason a witness may be relevant. And so we'll take these one at a time with Ms. Yerdey. I'll deny the motion to quash, and if your election into proceed in your presentation of the evidence is to call her, then that's what we'll do.
Thank you, Judge. So, Mr. Bradley, you may be excused for now. Thank you, but subject to recall.
Interesting.
We will call Ms. Yerdey.
I have to say, I thought that she was going to jump out of her skin. I mean, it almost, well, okay, this is simply my opinion, but she most definitely fought hard for that, and he has to stay. The subpoena is not going to be squashed. That right there is denied, so they're going to call the next person up. All righty. Wow. Okay, I'm going to move ahead a little bit. Oops.
And have you been friends since 1990 or 91?
Yes.
Okay. When was the last time you spoke with Miss Willis?
March of 2022.
Okay. From 1991-ish till 2022, were you what you would consider good friends with Miss Willis?
Yes.
Okay. And did you all share personal information regularly?
Yes.
And did you even come and work with her at the DA's office?
Yes.
And when she needed a place to stay, did you let her stay at your apartment?
Yes.
It was a condo, right?
Condo, yes.
Okay. Do you remember approximately when she moved into your condo?
It was April of 2021.
Okay, great. And you know that Ms. Willis and Ms. Wade met at a conference in October of 2019?
I'm going to object to that, Your Honor, without a foundation for how this witness would know that. If Ms. Merchant can establish she has personal information of that, then certainly that's something the witness can testify to. But if it's she heard
Understood,
it
Ms. Cross. All right, Ms. Merchant, if you could lay the foundation.
Do you have information that Ms. Willis and Mr. Wade met in October of 2019?
I'm going to renew my objection, Your Honor. Information is not sourced to personal information. If the question can be rephrased, then that may address my concern.
So Judge, I just want to make sure that I understand. So they've objected to me calling Willis and Wade.
It's just a matter of foundation. If you can just rephrase.
Do you have knowledge of when Willis and Wade met?
I'm going to object again. Personal knowledge.
Overruled.
Wait.
Thank you.
She is overly frustrated. She reminds me of Elaine Hofstetter, if that's her last name, on a Johnny Depp and Amber Heard trial when Amber Heard's lawyer could not even get anything in because she was not framing the questions correctly. Now, she's framing the questions to try to elicit information that there's no foundation for. She's trying to get that in. And she's being blocked, and she better be careful, in my opinion.
Do you have personal knowledge of when Willis and Wade met?
Yes. She told me that they met at a conference. I don't know what.
Okay.
I'm going to renew my objection, Your Honor. Clearly, this is not firsthand information from this witness. It's hearsay that was.
But you said she told me.
Yes, it's statement against interest, Judge. If Ms. Willis.
Just pause.
I'm sorry.
Okay, Ms.
Yes.
Cross.
The representation of the witness, the testimony of the witness was that Ms. Willis, District Attorney Willis, had a conversation with her. There is no statement against interest. District Attorney Willis is not a party opponent in this case. The information that the witness has testified to came from Ms. Willis, and there's we have a hearsay objection to that.
Why wouldn't she be considered a party opponent in this context?
She's a representative of the state, Your Honor. This isn't private litigation or civil litigation. Obviously, the court's aware this is. Ms. Willis is not on trial. Ms. Willis is not a party to the litigation outside her obligation to pursue criminal charges for the state.
Ms. Merchant, I guess it's evolved into a hearsay objection.
Yes, Judge, and we plan on calling Ms. Willis to the stand. She's under subpoena, so hearsay will be cured. if there is a hearsay objection as far as that issue. But we do still think that it's a statement against interest. Ms. Willis has filed a document that states that they met at this municipal court conference. So,
Your Honor, I think maybe I can streamline a little bit. State will stipulate that District Attorney Willis and Mr. Wade met in October 2019 at the judicial conference that we've been talking about. There's no reason to get it secondhand from this witness. That's true.
All right, you accept the stipulation, Ms. Merchant?
yes. Am I permitted then to ask questions about that, since it's now not hearsay?
If it's just to a stipulation, if it's just to that basic fact, I don't think we need a question, but if there's a follow-up that you think is admissible, go for it.
Ms. Yerdey, you have personal knowledge that Ms. Willis and Mr. Wade began their romantic relationship soon after this time that they met at the municipal court.
I'm going to object to that question. That certainly is a leading question. No foundation has been laid for how this witness would have personal knowledge of that. And until that's happened, the state objects.
Judge,
I think you can do a yes or no and then follow up with how she knows it.
thank you. Do you know if Ms. Willis and Mr. Wade started dating in October of 2019?
I don't know if it was October of 2019.
Could it possibly be November of 2019?
Could possibly.
Okay. And when we spoke, you said it was shortly after the municipal court conference, though, correct?
Yes.
Okay. So you know that their relationship, their personal relationship, began shortly after this municipal court conference?
Yes.
And when I say personal, romantic. I just want to make sure we don't get in an argument over what personal and romantic is later. When I ask you personal, do you take that to mean romantic?
Yes.
Okay. And do you understand it that their relationship began in 2019 and continued until the last time you spoke with her?
Yes.
And you were essentially her best friend during this time, right?
Not best friend, good friend.
Good friend. Okay, close friend. And so would you frequently socialize with her?
Yes.
And you saw her at work every day?
Yes.
So you had a chance to see them interact together on a personal level?
Yes.
And so from everything that you saw, heard, witnessed, it's your understanding that they were in a romantic relationship beginning in 2019?
Yes.
And when you left the DA, I'm sorry, let me ask you, you said that Ms. Willis came to live with you in April of 2021, I'm sorry, April 1st, 2020 or 2021?
She didn't live with me. I never lived with her.
Okay, I'm sorry. She took over your lease in April 1st, 2020, correct?
No, 2021.
Okay, I had it both ways, so I'm glad you clarified. So when she took over your lease in April 1st, 2021, it's your understanding she moved out of the house that she was sharing with her father and started staying at the condo?
Yes.
And is it your understanding that that's because she needed to have her own space?
Yes.
Away from her father?
Yes.
Okay. When you left the DA's office, was it, were you fired?
No, I resigned.
You resigned, okay. Just one moment, Jen. Can you tell us why you resigned the DA's office?
The number of things that was happening.
A number of things that were happening, is that what you said, ma'am?
Yes.
Okay. What was happening that caused you to resign?
It was a spiral of things. So, I guess the last straw is I was put in a department that I knew had no knowledge about. Something happened, and I didn't like it. They didn't like it. and that was it.
Okay. Did you have any falling outs with Miss Willis?
Well, we never spoke after that.
You never spoke after that. Okay.
Whoa.
And so you're, without going into all the painstaking details, there is no doubt in your mind that from 2019 until 2022, Miss Willis and Mr. Wade were in a romantic relationship.
What's the question?
You have no doubt that their romantic relationship was in effect from 2019 until the last time you spoke with her.
No doubt.
Okay. And that's based on your personal observations and speaking with them and seeing them together and things like that.
Yes.
Okay. No other questions. Thank you. The other folks may have some questions.
Okay. What I want to know is what happened. I mean, if they were ace boom coom and they were good friends, and then she was working there in the DA's office, then Fani comes in and they're friends, and then whatever happened, and she gets moved, and then they never spoke again. I want to know. Inquiring minds want to know what happened. Okay. Okay, so right now, I think they're done with her, or she may.
Questions for you, Mr. Yerdey.
Stay down.
You want me to go to the
If it's more than a couple questions, then sure. But if not,
It's only a couple questions.
Okay.
I think, can the court reporter hear me okay? Ma'am, let me be very specific. Did you talk with Miss Willis about her romantic relationship with Mr. Wade?
Yes.
Did Miss Willis tell you on more than one occasion that she was engaged in a romantic relationship with Mr. Wade prior to you leaving the district attorney's office?
Did she tell me or did I observe?
I'm saying right now what they tell me.
Yes.
Did she tell you that in the year of 2020?
Yes.
In the year of 2021?
Yes.
Are you certain that Miss Willis told you about the romantic relationship with Mr. Wade prior to November 1st of 2021?
Yes.
Now, did you also have observations of Mr. Wade and Miss Willis together prior to November 1st of 2021?
Yes.
And are those observations, were those in a social setting?
Yes.
And did you observe them do things that are common among people having a romantic relationship?
Yes.
Such as, can you give us an example?
Hugging, kissing, just affection.
All before November 1st of 2021, correct?
Yes.
That's all I have.
Mr. Stocks.
Ma'am, did I understand you to say that there was a period of time when you and Miss Willis lived together?
No.
Mr. Durham.
No, nothing from me, Your Honor.
Mr. McDougald.
Nothing, Your Honor.
Mr. Rice.
Good morning, Ms. Yerdey. Were you aware in 2021 of any trips, social trips, that Ms. Willis and Mr. Wade took together?
No.
Are you aware of any social trips that Ms. Willis and Mr. Wade took together in 2022?
No.
And are you aware of them in 2020 or 2021 spending the evening together overnight?
No.
Mr. Gillen.
No question.
Mr. McCullough. And Mr. Cromwell.
No questions, Your Honor.
Ms. Cross.
I do have some questions. Thank you, Your Honor. Ms. Yerdey, we haven't met before. Is that correct?
Correct.
You're able to see and hear me okay?
Yes.
All right. I want to start with a couple things. Now, I think you've made it clear that you never lived, and we'll call it the South Fulton address, the South Fulton condo that you were leasing. You never lived at that address with the District Attorney Willis, correct?
Correct.
And never at any time?
Never.
All right. You never observed or have any information about District Attorney Wade and District Attorney Willis and Nathan Wade living together, correct?
Correct.
You don't have any information about that?
No, I don't.
Anybody said that that information was sourced to you, then that's incorrect.
That's incorrect.
Did District Attorney Willis pay rent at that establishment, at that condo while she lived there and you were living elsewhere?
Yes.
Who paid the rent?
She didn't.
Nathan Wade ever pay the rent?
No.
And you never told anyone otherwise? I didn't hear your answer there, Ms. Yerdey. Did you ever tell anyone otherwise?
No.
All right. So let's talk for a second about your time at the District Attorney's Office. You were disciplined several times in the District Attorney's Office during your employment there, correct?
No.
You weren't written up ever for poor performance, Ms. Yerdey?
Once, not several.
One time you were written up for poor performance. Were you counseled several times about your performance in the District Attorney's Office that was subpar?
No.
Did the District Attorney tell you that your performance was insufficient and that you were going to be fired?
No.
That never happened?
No. Maybe when we went at the end. What's the question?
Okay, I get it. They were friends. And sometimes you have people that you may be here and the person may be here and the person who is here is not performing well. So if they become friends with you, then they can hold on to that job because they know you. But if you become doing subpar work, then you make them look bad. So she's mad. If she didn't resign, then she was going to get fired of poor performance. Oh, the plot thickens. Okay, that's a little bit dramatic.
The question, Ms. Yerdey, was did the District Attorney ever counsel you on your poor performance in the District Attorney's Office prior and inform you that you were going to be fired?
Yes, say it.
I don't really know how to answer that.
Yes.
I'm looking for the truth.
I don't really know how to answer that. I mean, a situation happened that wasn't my fault, and I either was going to resign or be let go. So
You understood that that was the situation. You could resign or you could be let go.
correct. Yes.
You were not welcome to stay.
No.
And the conversation where you were informed that you could resign or you could be fired, that conversation was not the first conversation you had with the district attorney about your poor performance in the office, correct?
Well, it was kind of a spiral, but no.
Yeah, it was. Whatever the situation was.
Excuse me. Understood, Mr. Sato. Ms. Cross.
Ms. Yerdey, the circumstances of your leaving the district attorney's office ended your friendship with the district attorney Willis, correct?
Yes.
Y'all haven't spoken since?
No.
All right, I want to talk about the representations that you made here this morning, Ms. Yerdey, about any relationship between District Attorney Willis and Mr. Wade. I want you to tell me what was the first time let me ask it this way. You said that District Attorney Willis personally informed you of a romantic relationship. Is that what you testified to?
Yes.
When did that conversation that you purport to have to recall, when did that happen?
I mean, I don't have a month or a day, but just talking in general.
Your Honor, you'd like to keep this this witness under subpoena, but that's all the questions I have right now.
All right, thank you, Ms. Cross.
I recross that. I mean, redirect, I'm sorry.
All right, on those points only.
Yes, just those points. The state asked you a lot about when you were let go, when you resigned. Did something happen as far as purchasing that you didn't feel comfortable with, purchasing things through the county for Ms. Willis that caused you to not be comfortable working there anymore?
No.
And I didn't tell you how to testify here today, though, right?
Right.
Okay. And everything you've testified to is from your personal knowledge?
Yes.
Okay. And you've told the truth here today?
Yes.
Okay. Judge, I believe she's only under my subpoena, and I'm fine releasing her from that subpoena. Oh, I'm sorry.
By show of hands from other counsel, starting with Mr. Sadow.
Your Honor, I believe the door's been opened now to ask this particular witness about statements that Ms. Willis made to her.
She brought it up on cross-examination on a couple of occasions. Did Ms. Willis say this or inform you of that? So I'd like to now ask her questions directly about what Ms. Willis told her about her romantic relationship.
I think we'll take those one at a time, question by question, and we can address those to see. I don't know about a complete opening of the door. We'll see where we go.
The first time that you spoke to Ms. Willis about her relationship, romantic relationship with Mr. Wade, do you happen to remember what Ms. Willis said? In essence, not word for word, but in essence what she said.
No.
Do you remember the first time she told you, in whatever words were used, that there was a romantic relationship?
No.
Is this the kind of conversation that you had with your best friend, ongoing over a period of time in which it was common knowledge to you that there was an ongoing relationship between Ms. Willis and Mr. Wade?
What's the question?
Yeah, I'll ask it again. Is the nature of your then relationship with Ms. Willis such that you were having these ongoing conversations, that is, best friend type conversations, about her relationship with Mr. Wade?
I don't remember.
Without getting any further in too much detail, is there any doubt at all that Mr. Wade and Ms. Willis had a romantic relationship, as was told to you, prior to November of 2020?
She was already asked that question by Ms. Merchant.
I just didn't know whether that needed to be.
She said no doubt.
No doubt.
All right. Any other defense counsel by show of hands? Seeing none. Last recross from Ms. Cross. Anything else?
Not at this time, Your Honor, but we'd ask the witness remain under subpoena and subject to recall.
Judge, she's under my subpoena, and I'm releasing her from my subpoena. So if they want to subpoena her, they're welcome to do that.
Ms. Cross.
I would prefer that the court keep her under subpoena. I think,
Sure.
Given the representation of Ms. Merchant, given how she intends to proceed today, that this witness may need to be recalled.
All right, understood. In the interest and knowing that we may have to bring witnesses back and forth, I think it's in the interest of effective presentation of the evidence here. Ms. Yerdey, you are still going to remain under the auspices of your subpoena, and so please stay in touch with your attorney. We may need you to rejoin us on Zoom at some point today or tomorrow. Understood?
Okay.
All right, don't discuss your testimony with any other potential witnesses, all right?
All right.
All right, you can log off.
And Judge, I'd ask, can Mr. Partridge stay on for just 1 moment?
For what reason?
The state had made some allegations that I misrepresented some things to the court, and I'd just like the opportunity to clear that up, that Mr. Partridge is the one that told me that they lived together for a month. They've called me everything but a liar today, and so I just think that it's appropriate for everyone to know where that information came from.
All right, Ms. Merchant, I think you've made your position clear. I don't think we need to get sidetracked on that. All right, Ms. Merchant, you can call your next witness.
Thank you. We call Mr. Wade.
Judge, may I be excused as well, please?
All right, take care, Mr. Partridge.
We call
Yes.
Mr. Wade.
All right. Ms. Cross.
Your Honor, the motion to quash Mr. Wade's subpoenas was held in advance, waiting for the representation. I believe that the good faith basis that Ms. Merchant represented on Monday, I think that's
Okay, I'm going to move ahead
understand the testimony that's
and get to the
now
next
in the
person.
record. Mr. Wade is
Oh, this is going to get good.
Thank you. No.
Sorry. Okay, Mr. Wade is going to come up. This is going to be very interesting. I think I went back a little bit too far.
You again responded to an interrogatory. You updated those responses on May 30th, 2023?
Yes, ma'am.
Okay. And you actually sent those directly to opposing counsel in the divorce?
Okay, now I did this one yesterday. I did half of it, so I'm going to move ahead. Please forgive me. Okay.
Written proof that you have of a trip she paid for?
That I have?
Yes.
Yes, ma'am.
Okay. So you submitted the one piece of written evidence that you have that she paid for something. Everything else is in cash. Is that accurate?
No.
That's not accurate. Okay. Please tell me what.
Okay. This was from a little bit that I recorded yesterday. Oh my goodness. He frustrated her to no end. So.
What other receipts do you have then that show that she paid for things?
I don't have them.
Okay. So this is the only receipt that you have to show that she paid for travel?
That I have, yes, ma'am.
Thank you. Okay. In your divorce case, you filed a domestic relations financial affidavit, correct?
Yes, ma'am.
Okay. The first one you filed was in January 2022, right?
Thereabout, yes, ma'am.
And those are under oath?
Yes.
Okay. And you also filed corporate taxes in 2022, correct?
Did.
Okay. And tell me about your business. Do you have a partnership or are you a solo practitioner?
As it stands today?
Yes.
So today, I have a separate PC. My law partner has his own separate PC.
Okay.
So, but we're under the same umbrella, under the same roof. So we share expenses, we share income, and we split it.
So are you a partnership?
We are a partnership in the sense of we share expenses,
we share income.
Are you registered with the state of Georgia as a partnership?
So, the WBC firm.
Okay, he's driving me nuts. LLP, Limited Liability Partnership. That's all he had to say, but no. Okay, I'm done.
That included myself, Terrence Bradley, and Christopher Campbell. We were registered with the Secretary of State as a partnership for a short period of time. When
that was dissolved, though, right, in 2023?
I'm going to object to the witness answer his question.
Mr. Wade, do you have something else to add there?
I did. When things happened and we excused Mr. Bradley from that partnership, it left Christopher Campbell and myself. So now you have two separate PCs under the same umbrella, sharing expenses and income.
Okay. So let me just narrow down my questions then. Are you registered? And have you been registered at any time in the state of Georgia as Wade and Campbell?
Wade, no, ma'am.
You've never been registered as a partnership?
As Wade and Campbell, no, ma'am.
Wade and Campbell, yes, thank you.
But as Wade Bradley Campbell, yes, ma'am.
Wade Bradley Campbell was registered on April 1st, 2021 and administratively dissolved on September 8th, 2023, correct?
Yes, ma'am.
Okay. Other than that partnership, you have always been registered as law office of Nathan Wade?
Yes, ma'am.
Not with Chris Campbell?
Correct.
Okay. Thank you. So the affidavit that you filed in your divorce case, the first one in 2022, think I'm up to number 7. I'm going to just give you a group of exhibits so we don't have to go back and forth. I'm marking the 2022 as 7. I'm marking the 2024 as 8. I'm marking the credit card statements as 9, and your taxes as 10.
I object to taxes because of the relevance of them at this point. The relevance of this entire business structure doesn't seem clear to me as either impeaching or relevant to the issues that the court's under the court's consideration. But insofar as we're talking about tax returns and other things like that, certainly that's should be redacted, and I would object to the relevance of it.
I agree they should be redacted. I don't agree to the relevance, but I haven't tried to tender them yet, Judge. I'm just marking them right now so that everyone can follow.
All right. And what is the eventual relevance that you were getting at here?
Well, I'm going to ask him because one of the things that we have to show in this case is a personal and financial interest. So, and he's talked about how he was reimbursed for these things, and so I have a right to go into the veracity of those statements. So let's see, 7, 8, sorry, 9. And then 10. All right, so right now I'm just going to show you what I've marked as these exhibits.
Ms. Merchant, may I see what you're showing?
Oh, yeah, of course. They're all from the USB drive I gave you. Other than the drive I gave you. I'm just. Can I approach, Judge?
You may.
I'm just showing you what I marked as 7, 8, 9, and 10.
All right.
Just so you have them for your reference as I ask you some questions.
All right.
So, so these are sworn. I'm first going to ask you about the domestic relations financial affidavit. These are sworn. They're filed under oath, correct?
Yes, ma'am.
And the most recent one that you filed was filed on January 26, 2024?
Yes, ma'am.
So a few weeks ago.
Yes, ma'am.
And in that one, you said that you made $9,500 each month, correct?
Yes, ma'am.
You said that in 2022, well, in 2022, in this case alone, isn't it true you were paid $303,000, over $303,000?
I was paid?
Yes, in this case, Fulton County, by Fulton County.
I see where you're going. So,
and Judge, I just asked him to answer the question. If he wants to explain it, I've got no problem with that.
Mr. Wade, just listen to the question asked and just answer the question asked. And if...
In 2022, isn't it true you were paid over $300,000?
No, ma'am, that is not true.
You were not paid over $300,000 by Fulton County?
No, ma'am, I was not.
Okay. How much were you paid in 2022 then?
So, what I was beginning to explain was Fulton County wrote a check to my firm.
Okay.
What happens at that point is the checks are then deposited. As you have the bank statements, you see that. And then they are dispersed between the three of us. So there was Mr. Bradley, there was Mr. Wade, and there was Christopher Campbell. A third. So when you ask me if I was paid $300,000, the answer is no. I got a third of that went to my personal firm. Now, once the money was distributed to my personal firm, obviously the expenses come out of that, and I get, at the end of the day, whatever the profit is. So I did not get $300,000. No, ma'am.
And let me just clarify. My question was not, did you put in your pocket $300,000? My question was the law firm of Nathan Wade paid over $300,000 in the year 2022?
Again, a third of that came to the law firm of Nathan Wade.
So you're saying that the law firm of Nathan Wade did not receive checks from Fulton County government over $300,000 in the year 2022?
That's a different question. A third of the $300,000 came to Nathan Wade.
Okay. This guy is slippery, and he is too much for her. Yes, his law firm did get over $300,000, but he said, like, no, third one here, and third one here. I only got a third of it. But, for, you know, between all the law practices that were in together, that was in the beginning. Now, one of the partners left, and then the two, or he was left as the office of Nathan Wade, and then had the other gentleman, I don't quite remember his name, that was still not underneath him, but still was practicing law under him. Yes, you received over $300,000. It was cashed into one bank. And if you want to say it was divided all over the place, you can say that. But still, when that check was cashed, it was cashed into the company account. You're frustrating that woman.
Again, I'm not asking what went in your pocket. I'm asking, was the law firm of Nathan Wade paid over $300,000 in 2022?
Yes.
I know, but I think we're dancing around the point there. So, final time, Ms. Nurse.
That's fine. I can move on, Judge. Thank you. So you said that they were dispersed amongst all of you, or put into an account with all of you. So it's your testimony that for 2022, every check you received from Fulton County government went into an operating account with you, Bradley, and Campbell.
No. That's not what I testified to. So the Wade, Bradley, and Campbell firm established an account when we decided to purchase a building in 2022. At that point, every piece of income that came into the entity went into that account.
Okay.
And then after expenses were paid, it was split a third, right? Once that was dissolved, then the funds would go into a different account, my account, one of my accounts. And then I would disperse the funds between now Attorney Campbell and myself, one half and one half.
Okay.
Make sense?
It does. Let me,
Okay. Wait a minute. Wait. He's saying way too much. He's saying that when the checks came in, it went to one account and that they were buying a building, and then monies were moved into his account to where he paid Bradley and the other gentleman their money. Okay.
Maybe more direct then. So the Synovus operating account that you had for Wade, Bradley, and Campbell.
Yes, ma'am.
The checks from Fulton County from January of 2022 until June 17th, 2022, those checks were deposited in that operating account.
Yes, ma'am.
Starting on July 15th, 2022, the checks you received from Fulton County up until May 26th, 2022, all went into an escrow account that you had at Fifth Third Bank, correct?
No, not all of them.
Not all of them?
Some of them, yes.
So it's your testimony that some of your checks from July 15th, 2022 up until May 26th, 2023, some of them went into an account outside of Fifth Third Bank?
No, check to the relevance of the financial transactions.
How much money you made is highly relevant in this case. It's the personal financial business and where the money was, and I mean it's just a follow up on other things that he's testified to.
And why is how much money he made relevant?
Because he represented it's very relevant. He filed an affidavit with the court saying, with another court, he told another judge that he made $9,500 a month. That's what he swore to. And
all right, so this entire inquiry is just to establish that prior and consistent statement.
Yes.
All right. I'll give you a minute or two more to try that, but we're going to have to move on.
Thank you. So I know you're saying that you only got a third of the $300,000, but you were paid over, the firm was paid over $300,000 in 2022, correct?
So, Ms. Merchant, it's not what I'm saying. They're numbers. They're there. It's the truth. The funds were paid. They were divvied between the three of us, going into an operating account. Expenses paid out of it.
Okay.
At the end of that, the 9,000 figure is what you have.
So that's where you got the 9,000 figure from.
Yes, ma'am.
And let's see. Let's
Wait. Stop the press. Wait. He's saying out of over $360,000, he only got $9,000 out of it? Really? Okay. I'm going to leave it right there. Look at that smirk on his face. Look at him. You're not going to get me, woman.
Prior to when you filed for divorce in November 2021, you would use Mr. Bradley's credit card to pay for things with Miss Willis, correct? And then pay him back in cash.
I've never used Mr. Bradley's credit card.
You've never used his credit card?
Never.
For transactions to anything with Miss Willis? Out to dinner, anything like that? Hotels?
I've never used Mr. Bradley's credit card. I've never used anyone else's credit card. Not even my father's, and we have the same name.
And you'd pay back, if you ever did use someone's credit card, you'd pay back in cash, though, correct?
Ma'am, I've never used someone else's credit card.
Can you take a look at the bank records that I gave you? That's the largest tab you have.
For the record, which exhibit is this?
It is exhibit, hold on, Judge. It's exhibit 9. It should be the largest section you've got.
Your Honor, before there starts questions from the exhibits haven't been tendered, and I maintain my relevance objection.
All right, let's see what the next question is, and maybe then that objection is going to be highly relevant.
Okay.
Is that an accurate copy of your Capital One statements that you provided in discovery to, is that an accurate reflection of your Capital One records?
That I provided in discovery to whom?
To your divorce lawyers, or that you provided in the divorce proceeding.
Is the question, does he recognize it by sight?
I'm asking if it's his statement, his bank
I
statement.
think that is the question.
Well, I mean, it's a thick document, but I believe you if you say that this is what my wife's divorce lawyer gave you. I believe it.
Your name's on every page of that document, correct?
On every page?
Pretty much every page, if not every page.
No, it's not on every page, no ma'am.
They're all Capital One bank records showing.
They are.
Okay? Just take your time, look through it. Tell me if there's anything that you think is not yours.
No, they appear to be.
Okay. And those bank records show that you paid for travel with Miss Willis.
Yes, ma'am.
Your Honor, I'm going to object the relevance of these documents and the.
Well, I think, are you tendering Exhibit 9?
I'm going to, Judge, and they're highly relevant to the whole
Well, you've asked him a question about the contents of them, and they haven't been admitted yet. So why don't we start there?
Thanks. Those show travel that you and Miss Willis took.
Well, so you're asking about the contents of something that hasn't been admitted yet, right?
Well, I'm asking him if that's what it shows because I know that they're going to object on relevance.
Well, first we got to see if it's you've authenticated it, perhaps, and before we get into other details of what's in it, I think
I can
it has
tender
to be
them. That's
admitted.
fine. I move to admit them.
All right.
Object on relevance.
On relevance. All right. And on that, overruled. Ms. Merchant.
Thank you. Those records demonstrate that you paid for travel with yourself and Miss Willis, correct?
They should.
Okay. And let's just talk about that travel.
Okay.
The first trip is Belize in March 2023. Is that a trip that you took with Miss Willis?
Are you asking?
Did you take a trip with Miss Willis in 2023 to Belize?
I did.
Did you take a trip to California with Miss Willis in 2023?
I did.
Did you pay for those trips on that credit card?
I used the credit card to book the travel, but understand.
She paid you back cash.
Well, let me say this. Let's take the Belize trip, for example, since you started there. That was a birthday gift to me, so I paid nothing for that trip. Zero.
Okay. So the charges that are on your card, she gave you cash for?
She did.
Okay. So all of the charges...
Excuse me, Your Honor, but the witness had finished answering the question.
Oh, did you have more?
I did.
Okay.
I wanted to get into the charges on the card because traveling with her is a task. You can probably imagine the attention that happens. So for safety reasons, she would limit her transactions. I mean, imagine trying to walk through an airport or sit at a restaurant or do anything.
Okay. I didn't mean to do that. I didn't mean to do that either. I am so sorry. Okay. Now, keep in mind, Fani Willis has been prosecuting a lot of these rappers and big time people that have done some things that should be looked at and possibly put in jail. Now, he's saying that he's leading into that her accepting anything from him is a task. Now, a friend of mine, we've had a conversation about this, and she is of the mindset that in their relationship, she pays him back for whatever he buys for her most of the time. I'm of the mindset of, no. Women are not going to constantly give a man money back when they take her someplace. No. No.
There's no attempt to conceal. It's a credit card. Everything is here. So.
And that's not what I asked.
Okay.
What I asked was the charges for Belize in March 2023 on that credit card. Those are things you purchased to go with Miss Willis to Belize.
Those are things that we booked with my card that she paid. Yes.
Yes. So those show up on your credit card.
They do.
And you're saying that she paid you cash to reimburse you for all of that.
She did.
And she paid you cash for both of your portions or just hers?
Both.
Okay. So that trip, Belize, just Belize, she paid you for everything on Belize.
The entire trip.
Okay. So the food, tattoo parlor, all that stuff, she paid for.
I'm sorry, maybe didn't hear the question.
There was no tattoo parlor in Belize.
The charges, there's a tattoo parlor on the charges. I'm not getting into what it was for. I'm just asking if everything that's on that card related to Belize, she paid you back for.
She paid for, yes, ma'am.
Okay. Let's talk about California. In May 2023, you all went to California together.
Yes.
And you booked plane tickets.
Yes.
And her name was on those plane tickets.
They were.
And so I know you said that you were worried about security and things like that, but that was in her name. When she traveled, she had to use her name.
Oh, so the plane tickets, yes, ma'am.
Mm-hmm. Okay. And you paid for those plane tickets, and you paid for a hotel.
So, again, the card, yes.
You used your credit card, and I'm not asking about after what happened. I'm asking, did you use your credit card to book your flight and hotel to California?
I did.
And there's a lot of Ubers on there as well for California. Did you pay for those Ubers as well?
Yes.
We
were in Napa.
And you're saying that Miss Willis, are you saying that Miss Willis paid you back for that?
Yes.
Did she pay for the entire trip, or did she pay for her half of the trip?
the Napa trip, she paid for the excursions, so the expenses sort of balanced out. I mean, there was never, let me be clear, there was never a time when I would say, hey, I bought dinner. Dinner cost $25. You need to give me $25. If you've ever spent any time with Miss Willis, you understand that she's a very independent, proud woman.
I'd object. Not.
So she's going to
overruled, Mr. Wade.
So she's going to insist that she carries her own weight, and it actually was a point of contention between the two of us. She is going to pay her own way.
So let me re-ask the question to make sure that you answer it. A California trip that you paid for, saying that she did not pay you back for cash. Instead, she paid for excursions, and you believe that was roughly half.
No, she gave me some cash, yes. But what I'm saying is everything that we did when we got into Napa, she paid for.
The trip that she booked on her credit card in Miami, did you pay her cash back for your half of that?
No.
So you never paid her back for the ticket she bought for you?
No. I would say I did pay her back because there were times when I would pay for dinner.
Okay.
She would pay for dinner. It would balance out. But in a relationship, ma'am, you don't, particularly men, we don't go asking back for anything. So you're not keeping a ledger of things that you pay for versus the thing that she's paid for, which is why I said that it was a point of contention, because she was very emphatic and adamant about this independent, strong woman thing. So she demanded that she pay her own way.
But she's the district attorney of Fulton County, and she has to file financial disclosures disclosing any gifts with anybody that she does business with in Fulton County, correct?
I don't know.
Okay. Let's talk about Tennessee. You booked a cabin in August 2023 and paid for a cabin in Tennessee. That's when you paid for it. I don't know when the trip was. Can you tell us about that?
August of 2023?
You booked a trip for $1,481.54.
Are you asking me, did I take that trip with Miss Willis, or are you asking me?
First, I was just asking you to acknowledge that that is correct from the records, that you paid for a cabin in Tennessee. Do you recall, and hopefully you can do it from your memory, do you recall paying for a cabin 6 months ago, $1,400.81 in Tennessee?
Where are we now? What page is that?
I'm just asking from your memory. Do you remember paying for a cabin in August?
John, if he's going to be asked about a particular transaction, then
You can answer whether he remembers or not.
Mr. Wade, I'm not asking you to go through 1,000 pages of records. I'm asking if you remember paying for a cabin 6 months ago in Tennessee.
No.
You remember booking a cabin?
I booked lots of cabins.
Did you go to a cabin with Miss Willis ever?
Ever?
Ever.
No.
You've never gone to a cabin with this?
No.
You ever gone to Tennessee with Miss Willis?
Yes.
Okay. When was that?
That was around 2022, early 2022.
Early 2022? Okay.
It was a day trip.
Okay, so you didn't spend the night?
So it was a day trip.
Okay.
We would drive there, have lunch, drive back. The reason we would do that is because the attention, she couldn't get any peace of mind going locally, so we'd get in my car and drive to someplace off the beaten path and have lunch and drive back.
Is that when you went to Feigning Goat? Okay. I think it's in Jasper, Georgia.
No, that's in Georgia. I don't recall going to Fanning Goat with her.
So the Tennessee day trips were only Tennessee.
Yes.
Okay. Did you ever do these day trips in Georgia?
Did we drive anywhere in Georgia?
Yeah, you were talking about day trips going out, and I'm talking about outside of the metro area. Day trips that you were just talking about. These trips you were talking about. The ones that you were, I'm only asking about the ones you were just talking about. Are all of those in Tennessee?
No, we drove to Alabama before.
Okay.
Back.
You drove to Alabama?
Mm-hmm.
Did you go anywhere in Georgia? North Georgia?
You know, I'm going to object. If he wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the witness to accurately answer.
Ms. Merchant, I think if you don't have the specific details yourself, we need to start getting into specifics or more maybe broadly phrased questions.
She's fishing.
Exploring around indefinitely.
Is it fair to say that you've taken so many trips with her you don't even really remember all the places you've gone?
So many trips?
You're having trouble remembering going if you went to North Georgia or not.
Were you asking me about specific places? And I want to be candid in my responses, so I have to jog my memory because these are places that I have frequented, but not with her. So I want to make certain that if there was ever a time that she accompanied me, that I was candid in that response.
Okay. Aruba, October 2022. And I've got business record certificate for these, Judge. It might be a little faster. But did you take a trip with her to Aruba in 2022?
Yes, ma'am. So that Aruba trip there was a package deal there. My mother had recently retired, and I decided to take my mother on a cruise.
Okay.
And the second leg after the cruise concluded, D.A. Willis and I went to Aruba. So that was all one trip, if you will.
Okay. So my question was, did you go with D.A. Willis to Aruba in 2022?
I did.
Thank you. And you paid for that trip using your business credit card, correct?
I did.
Okay. And you paid for a cruise as well, correct?
That's the cruise I was referencing with D.A. Willis, my mother, and myself.
Okay, and because there's two cruises, so let's just talk about the first one.
Okay.
So the first one was that's the one with your mother.
Yes.
And so you introduced D.A. Willis to your mother. That trip, you all took a cruise together, the three of you.
Yes.
After the cruise was done, you and D.A. Willis flew to Aruba together, and your mom flew home.
Yes.
And you paid for all of this with your credit card, on your business credit card.
I did.
And are you saying that Ms. Willis paid you cash back for that?
She did.
And
But let me make this distinction though, because the number that you're looking at reflects the three people on the cruise ship. There were things that my mother and I did, just the two of us, that D.A. Willis didn't do.
And I'm not attributing that. I did not. My math is not good, but I did not include anything with your mother on those.
You wouldn't be able to see it because it's not separated out. It just shows a charge on the account when actually it would have been something with my mother and I.
Judge, may I approach with exhibits 10 and 11? They're both certified business records one's from Vacation Express, one's from H2.
I thought 10 was taxes.
I'm sorry, 11 is golf.
Okay, while she's doing that, I'm going to speed ahead a little bit because it's going to go around and around and around. Okay, let me just let it go.
And These are business records, Judge. They have the certifications. I need to admit them.
She keeps on asking the same questions in different ways in a circle
11 and 12.
when she didn't lay a foundation from the very beginning.
They are true and accurate of
So-
the certification that was provided to her. You have no objection.
All right. Again, seeing no other objection, they're admitted.
So the trip, just the trip to Aruba alone, for you and DA Willis was $3,835.26, correct? Just Aruba.
I'm looking for the amount.
Which exhibit? Question about 11 or 12.
This one is 11.
Yes, ma'am. $3,835.26.
And then the Royal Caribbean for just you and Miss Willis was $1,269.70, correct?
No, ma'am.
Your mother's got a different line item on there. I'm talking about the cruise, the actual cruise cabin.
I think you need to rephrase that as in the form of a question, Ms. Merchant.
Did you pay Royal Caribbean for yours and Miss Willis's cabin $1,269.70?
Where are we? Which page?
We're on the receipts. There's just a few pages of receipts on exhibit number 11.
Okay. I'm in 11. Can you direct me to where you are on in exhibit 11?
The receipt for Royal Caribbean.
No, we drove to Alabama before.
Okay.
Back.
You drove to Alabama?
Mm-hmm.
Did you go anywhere in Georgia? North Georgia?
You know, I'm going to object. If he wants to direct his attention in some way to a time frame or a location, then I think it might be easier for the witness to accurately answer.
Ms. Merchant, I think if you don't have the specific details yourself, we need to start getting into specifics or more maybe broadly phrased questions. You can't just be exploring around indefinitely.
Okay, I'm going to move it ahead.
Is it fair to say that you've taken so many trips with her you don't even really remember all the places you...
Okay, I'm going to move it ahead a little bit. I'm sorry.
That and confirmed prior to its tenure.
All right, Ms. Merchant, is there anything else? What other areas were you planning to cover on his direct other than these documents?
I'm planning on introducing all of the contracts and invoices, but I haven't had a chance to look at what Fulton County certified. So I'm planning on introducing those and then not much.
Can we do the not much? We'll do the not much, and then we'll get back to the contracts.
Okay, yeah, definitely. Okay, so this taint contract, and we're not admitting these right now, but if I represent to you that they say anti-corruption unit, can you tell us what a taint attorney for an anti-corruption unit would do?
I didn't have a part in those contracts.
They were your partners at the time, though, correct?
Oh, absolutely.
Okay, and so you didn't have a part in those contracts, but you got a third of the contract payment.
Oh, absolutely.
Okay, so the taint contracts that Bradley and Campbell, who are your law partners at the time, had for doing taint review, you got a third of those.
Yes, ma'am.
Okay. You signed a confidentiality agreement with the DA's office as well, correct?
I did.
And I think I'm up to Judge 13. Marking that as number 13. Yeah, approach, Judge.
You bet.
Showing you a copy of what I marked as number 13. If you could take a look at that and tell me if that is the confidentiality agreement that you signed with the district attorney.
It is.
Okay. And this basically says you can't talk about anything that happens inside the DA's office, right?
No.
It doesn't say you can't talk about it?
No. You said it basically says that I can't talk about anything that happens inside the DA's office, and that's not what.
Are you tendering this exhibit?
I am, yes. We would tender 13.
Ms. Cross.
Fail to see the relevance, I lodge a relevance objection, but otherwise.
Ms. Merchant, relevance of this?
Judge, it's relevant to his testimony. If he signed an agreement that says he can't talk about things that happen in the district attorney's office, I think that's relevant to this. I also think
How?
that because it's motivation in his testimony. I mean, whether or not he's going to testify to something. It's also been certified. I mean, it's part of the record as from what Fulton County gave us.
Sure, but he hasn't said that that's preventing him from testifying in any way today, is it?
No, and I can ask him about that.
Okay.
Yeah.
Mr. Wade, is this confidential agreement affecting your testimony today?
No, sir.
Okay. All right. That's fine. Let's see. The contracts judge and the invoices that I wanted to admit all of his invoices and contracts with Fulton County. I have them certified. I guess I have them certified through Fulton County, so I wasn't sure if I needed to do that. I just wanted to know if the state had an objection to those before.
Well, they haven't had. I don't think they've had a chance to look at them. So that's the sole remaining exhibit in line of questioning here?
Yes.
And in terms of the follow-up questions, would it just be for him to say what's reflected in these documents themselves?
If they have an objection to the certificates that Fulton County has given, I would admit them through him because he could recognize them.
But assuming they're admitted, would there actually be anything substantive he would add other than the documents themselves? No. All right. Okay. So subject to that qualification, do you have any other questions of this witness?
May I just have a moment?
Sure.
Thank you. Is it possible actually we take a quick break?
We're getting there.
Okay. Thank you.
And we certainly have the opportunity over lunch to take a look at these documents and work out whatever we could.
Did you discuss your relationship with Miss Willis in social settings?
Help me understand your question.
Did you discuss your relationship with Miss Willis in social settings?
No, I heard the question. I just need to understand what you're asking me. What relationship when
your personal relationship with Miss Willis? Unqualified, I'm sorry. Did you discuss your personal relationship, your private, personal, romantic relationship with Miss Willis in social settings?
No, ma'am.
You've never discussed it in social settings?
No, ma'am.
Did you ever discuss it in front of Robin Yerdey in a non-social setting?
No, ma'am. Miss Willis is a very, as am I, we're private people. Not, our relationship wasn't a secret. It was just private. So.
Wait a minute. Wait. Okay, check this out. No, that's not how women are. Oh, she's very, very private. No. If you are just now in a relationship or you really like the guy and you say you're going to keep that to yourself, no. She went over to Mr. Yerdey. Yeah, girl, he is so good looking. Oh, my God. Yeah. That is what happened. What he's saying, no. He's looking from a male's point of view. Men don't really do the No. Men don't really talk like, well, they may, possibly. But she's not private. Girl, oh my goodness, his muscles, blah, blah, blah. Okay, I'm done.
No, not at all. I wouldn't have discussed my relationship with Miss Yerdey or anyone else publicly.
But she would.
I actually did have some questions just about the invoices. If you want to just...
These are the documents that you're referring to?
Yeah, they are. It's all of his invoices.
And what kind of questions would these be other than the invoices say what they say?
It just, yes, that they say what they say.
All right.
Just talk about them. That's fine. No.
All right.
Thank you.
All right. At this point, we'll take a break. I'll ask the parties to take a look at... had you marked that as a defense exhibit?
I have his contracts in his...
Okay, I'm going to fast forward.
So before he...
Okay.
me, I just want to make sure that the state doesn't have any objections.
So those are marked as...
They're about to be marked as...
Exhibit 14.
14, 15, 16, 17, and 18.
All right, so 14 through 18. So ask state take a look at those.
I will take a look at those and see if I can match them up with the certified documents that were.
All right, and then we'll address whether they are tendered for the record when we come back, and from there, then we would turn over to the remainder of.
So, I mean, that's where I turned.
No, I understand, but the difference in production, Ms. Merchant, you've taken a look at them, and they're actually material to your case.
Yes.
In what way?
They're all of his invoices, Judge, and then he has like it's just, this is what I got from them. It's all of his invoices, and one of the invoices is a reimbursement that he printed some things, but like for the reimbursement. I mean, I don't really care if they take the reimbursement out because they actually are already admitted in the other exhibit I did.
I don't have any problem with the invoices. The invoices are clearly the records and contained in the certification. So if we remove the items that are in dispute, then I don't have an objection to the.
They're already in exhibit.
So you're removing them?
Yeah, that's fine. You want to take them out?
All right. So again, let's have opposing counsel look at a revised Exhibit 14, and then I'll hear whether there's any objection.
She's in it over her head, in my opinion. She didn't get straight to the point. She was walking all the way around the corner instead of just taking a straight shot. Wasted a lot of time, in my opinion, asking the same questions in different ways over and over and over again. Let me speed this up.
The revised exhibit number 14 contains only the invoices that were submitted, and the state has no objection.
All right, then, not seeing any other issues from other counsel, we'll note Exhibits 14 through 18 have been admitted for the record without objection. I think at this point it'd be good to make sure we've got, I think, 1 through 18 with the court reporter.
Others, but do you want me to give them to the witness?
Let's, if he's done looking at them, let's just get them all compiled and organized and with the court reporter in case other defense counsel are going to reference them. No, it wasn't for him to have them all. We just need to have 1 through 18 organized with the court reporter. Yeah.
So you want me to take all the exhibits back from him?
I think we ought to do that.
I will do that. Thank you.
Yeah. This is
Okay.
That paper. To ask the same question
All
over
right,
and
as
over and
Ms.
over
Merchant
again.
is doing that, let me go down the list. Mr. Sadow.
Your Honor, if the court will permit, Mr. Gillen is going to ask some questions, and I was going to ask, I'd like to be able to just follow up if there's anything that you'd like to touch on.
Let me just to keep it consistent, I'll go in order. So if Mr. Sadow is deferring, then I'll go to Mr. Stocks.
I will defer to
Mr. Durham on Zoom.
No, Your Honor.
All right, Mr. McDougald.
I will defer to Mr. Gillen.
All right, Mr. Rice. All right, thank you, Mr. Gillen.
Uh-oh.
Thank you, Your Honor.
I don't think this is going to go so
Good
well
afternoon,
for
Mr.
him.
Wade.
Good afternoon, sir.
A few follow-up questions. I'd like to start off with the exhibit number 4 that you should have up there. Those are the interrogatories.
No, sir.
They're not up there?
Remember, I asked her to compile them all, so
I'm
now you
sorry.
can grab
Right
them.
here, I'm going to give it to you. If you wanted me to come.
Yes, sir.
Okay. Now, these are the interrogatories that you had filed on May the 30th, 2023 in your divorce case, correct?
Yes, sir.
Now, you went over in part some of those interrogatories, but what I want you to do, because I want to get down to the specific language to clear up exactly what the interrogatories asked for and exactly what you answered, okay?
Yes, sir.
Now, if we look on the interrogatory that I believe, as we indicated, there really, I think, on page 2, the one that starts off, describe each instance in which you've had sexual relations. You see that one?
Yes, sir.
Right. Now, that interrogatory begins, describe each instance in which you have had sexual relations with a person other than your spouse during the course of the marriage, including the period of separation. You see that?
Yes, sir.
Now, these were filed on May the 30th, 2023, correct?
Yes, sir.
Now, at that time, you had had sexual relations with Miss Willis, correct?
Well,
Your Honor, I'm going to...
Oh, he's going down. Oh, man. Oh, man. Okay.
object to the question as phrased. I think the question is properly, at that time, certainly asked about his answer, but I object to...
All right, Mr. Gillen, I just ask you to rephrase, but I think you can make the same point.
Well, Your Honor, it's a specific interrogatory, and I would, so the words do matter, and I would like him to answer whether or not he'd had sexual relations with Miss Willis, because if he answered yes, then this interrogatory is a false interrogatory. So I would ask the court's indulgence. I'm not here to jump into some salacious bedroom situation, but this is an interrogatory that matters. So I would ask the court's indulgence.
Ms. Cross?
These questions have been asked and answered several times. I understand Mr. Gillen is coming at it from a different way, but this question is not substantively different than those that have already been asked and answered in the information that he is seeking.
All right, Mr. Gillen, I'll allow maybe this question and one more, but I think you are asking it in a different way, and I'll ask you to stick to the point.
All right. Now, as of May the 30th, and may I ask the question that okay, thank you, Your Honor. As of May the 30th, 2023, you had sexual relations with Miss Willis, isn't that correct?
The interrogatory, sir, asks during the course of the marriage and the period of separation.
Excuse me.
My response,
Your Honor, I would ask that the court direct the witness to answer my question, yes or no. As of May the 30th, 2023, had you had sexual relations with Miss Willis? Yes or no?
Mr. Gillen, let's start with at the higher level whether he believes he answered it truthfully, and then we can drill down into why or why not he doesn't, and maybe we'll end up exactly where you left us.
Well, but again, Your Honor, the point of it is that the words matter, and that we have to establish what did and did not happen, and then he can give whatever explanation he chooses to what apparently is a false answer. But I would like an answer to my question.
And you may get one. I would like us to start at the high level before we drill down into specifics to see whether he actually contradicted that interrogatory, if I'm making sense.
Well, the interrogatory is relatively direct and explicit. Sexual relationships with a person other than your spouse during the course of the marriage, including the period of separation. That's pretty simple.
Sure. Let's see if that's something you can get him to admit.
You did have sexual relationships with someone other than your spouse during the course of the marriage and during the period of separation, which included up to May the 30th of 2023. Isn't that correct, sir?
My answer to this interrogatory is none, is no.
So you're saying that you did not have sexual relationships with anyone outside of your marriage, and the period of separation is during the period. Then you're answering the question to this interrogatory, correct, sir?
I'm saying during the course of my marriage, I did not have sexual relations to anyone, and this answer's no.
Well, again, Your Honor,
I understand. You can proceed, Mr. Gillen.
We need a yes or no. Let's just get down to it. Did you or did you not, by May the 30th, 2023, have had sexual relations with Miss Willis, yes or no?
Yes.
Yes or no?
Yes.
Okay. Now, what you did is you answered no to that question, didn't you, or none, correct?
I didn't answer no to the question you just asked. I answered no to the interrogatory question.
And the interrogatory stands that you answered as a pleading in a civil proceeding, your divorce case, right?
Yes.
Now, excuse me. The next interrogatory, let's move there. That interrogatory states as follows: identify any and all occasions in which you entertain a member of the opposite sex other than your spouse who is not related to you by blood or marriage. You see that?
I do.
Now, there are two parts to this. The second part is, I read on, or in which a member of the opposite sex, other than your spouse, not related to you by blood or marriage, entertained you. And then it goes on to say, including but not limited to dining, drinking, in restaurants, bars, pubs, hotels. You see that, correct?
I do.
Now, as of May the 30th, 2023, when you filed this interrogatory, you had in fact entertained Ms. Willis on many occasions, had you not?
Again, during the course of the marriage was irretrievably broken in 2015.
Well,
the answer's still no.
Let's read what the interrogatory says about the time period required to answer the interrogatory. Because what it says is, it goes on to say, including but not limited to dining and or drinking at any restaurants, bars, pubs, hotels, or persons' homes from the date of marriage to the present. You understand what the word present means?
I do.
And present means the filing on May the 30th, 2023. Isn't that right?
It is.
So as of May the 30th, 2023, you have done a lot, or you had done a lot of entertaining of Miss Willis, had you not?
I had done some, yes.
And in fact, under your testimony, you would have said that she had also entertained you. Isn't that correct?
Yes.
And so your answer to this interrogatory is false, is it not, sir?
No, it's not false.
Well, hate to dance around the... the answer is yes, you did entertain Miss Willis, correct? Right?
Yes.
She's not your spouse at that time or at any time, correct?
That's correct.
She's not related to you by blood or marriage, correct?
That's correct.
But you entertained her, right?
Look at his expression. Look at his expression. It changed from being smug to say, uh-oh, I'm in trouble. Look at his expression. He could fidaggle the woman, or whatever the word is, but he's not going to do it to this seasoned male lawyer, because he's like, oh, I know what you're doing. I'm a guy too. Oh, man, this is going to be good. This is going to be good.
Yes.
And during the course from your marriage, the period of time up to the present, so the answer would have been, yes, I did entertain somebody.
Does it look like he's getting ready to cry? Look! Because he's like, my wife is watching. She is going to ream me. She's going to... Oh. Okay.
Correct?
During the course of the marriage, no.
Mr. Wade.
Mr. Gillen, I think we've made our point. I think it speaks for itself, and we can save that for argument.
I'll just follow up with one quick question. You understand what the word present means?
Your Honor, that's been asked of us.
I think we did cover that already as well.
Okay. Now, what has happened from the time that you filed this court document in May of 2023, let's go over some of the things that you had been involved in terms of being entertained or entertaining. Prior to your filing on the answer on the interrogatories on May the 30th, 2023, we've already established, have we not, that you had paid for a Royal Caribbean cruise to the Bahamas with Miss Willis, correct?
Yes, sir, with Miss Willis and my mother.
Well, your mother's not a part of this interrogatory. I'm talking about Miss Willis, okay? So you paid and caused to be paid approximately $3,335 on that trip, Bahamas trip, from October the 28th through October the 31st, correct?
Your Honor, objection. I think we've touched this ground several times already.
Mr. Gillen, let's cover new ground.
Well, I'm just trying to establish with specificity the things that he had done to entertain or be entertained prior to May the 30th, 2023. I'll try to move through it quickly.
Sure. Well, that's already part of the record in terms of his prior testimony, and so if you want to link those two things together, you can do that during argument.
Well, so let me discuss this. You indicated that during the course of your explanation concerning the Belize trip, that Miss Willis paid you all that money back in cash. Remember?
Yes, sir.
Now, the Belize trip had just happened, hadn't it? That occurred in March 18th, 2023, right?
Yes, sir.
So you're filing this maybe 2 months after you have gone to Belize with Miss Willis, correct?
Again, I believe all of this is our...
I think you might be getting somewhere new. We'll see.
Uh-oh.
Yes, sir.
So we've got the trip in to Belize on March the 18th, 2023. You and Miss Willis, correct?
Yes, sir.
Now, 2 months later, you file the interrogatories that speak for themselves that we've gone over a few minutes ago, correct?
Yes, sir.
Now, the March the 18th, 2023, to state the obvious, is before May the 30th, 2023. Will you agree with me on that?
I do.
Okay. So then you tell us that Miss Willis paid you in cash all the money for the entire trip. It was a gift for you for your birthday, correct?
Yes, sir.
And I'm sure you probably have the deposit slips where you took the cash and deposited the cash into your account, don't you?
I did not deposit the cash in my account.
You don't have a single solitary deposit slip to corroborate or support any of your allegations that you were paid by Mrs. Willis in cash, do you?
No, sir.
Not a single solitary one.
Not a one.
Wait a minute, I'm sorry. This look is for one person, and I know you're watching. Fanny is that strong woman. Okay. All right.
Now, when Miss Willis would pay you in cash, would you scamper down to the ATM with her, and as she drew money out of her account
Your
to
Honor.
pay you these thousands of dollars?
Mr. Gillen might scamper, but there's been no evidence that Mr. Wade does. I object to the phrasing, the argumentative nature of the question.
All right. On that issue, overruled.
Did you and Miss Wade scamper down to the ATM machine and have her draw out, for example, on the Belize trip, just on your payment would have been $2,794?
Miss Wade.
For clarity, yeah, thank you.
Pardon
me? Miss Wade and I didn't go to Belize.
No, excuse me, Miss Willis. I'm sorry. Did you go down to the ATM with Miss Willis while she drew out $2,794 to pay you in cash? That you did you go to the ATM with her?
No, sir. She didn't go to the ATM. She carried the cash.
Oh, and so she would give you the cash. Did you have a little place in your house where you just stack up all this cash that you apparently got to repay you for these benefits that you bestowed on her?
And Mr. Gillen, if I answered that, I'm putting myself in jeopardy. If I tell the world that I have cash someplace in my home, don't you think that could be problematic?
No, I don't. I want an answer as to whether or not you have a little cash hoard in your house where you have allegedly taken the money that you got from Mrs. Willis and went and...
He said, Wade, where's that money at? You're not going to finagle this. You're going to... Give me the answer. Give me the answer. Tell it. Oh, my goodness. He is hammering them. Okay. Oh, my goodness.
Put it somewhere. Where'd you put it?
No, sir.
Now, just put it on the hip and kind of walk around money?
Did I put it on my hip?
Yeah, just walking around money where you would spend cash yourself?
Let me finish. Did I put it on my hip in Belize and walk around with it?
When you got paid back, would you take the money, the cash that she gave you, and would you just carry it around with you for spending money around town?
So we have to break down each trip because, for example, for the cruise, she paid me the money before we took the cruise. So I was here and I could put the money in my pocket or put it away wherever I wanted to do with it. Other trips, she would give me the money there. So at that point, I could either spend it or put it in my pocket or put it in the hotel safe.
There's no special place that you would have all this cash that you would be getting from her that you've told us about to pay back for the benefits that you have bestowed on her?
The only special place that cash would have gone would have been to one of my children.
Okay. Now, are you aware, have you discussed these pleadings with Ms. Willis?
No, sir.
So there's been no discussion between you and Ms. Willis about the allegation concerning the benefits that you have bestowed on her? Is that correct?
For the phrasing, the benefits bestowed upon, I don't believe that's an accurate reflection of the testimony, and I don't think that's an appropriate question.
I think overruled. You can answer the question.
Okay. When you said proceedings, are you talking about the divorce proceedings? Because we were talking about the interrogatories. To that question, the answer is no. If you're at, go ahead.
I'm sorry. Go ahead with your answer. I'll hear the complete answer, then I'll follow up.
Okay. If you're asking me about this hearing, the proceedings of this hearing, have we discussed the financial piece based upon Mr. Roman's motion? Yes.
So you have discussed the financial piece. Where did that discussion take place?
Conference room.
Were you other people there, or were you and Ms. Willis discussing this about what your position was going to be?
The relevance of this.
No?
Mr. Gillen?
And the relevance has to do with suddenly we have a declaration from Mr. Wade in this case where he says roughly equal and then shows one alleged payment by Ms. Willis. No mention of cash, none. So I need to find out a little bit more about how suddenly we have this revelation about cash from the witness stand today.
Overruled.
So we part company there when you say no mention of cash. If I provided one receipt that didn't amount to what you would think was roughly equal, the rest of it is cash.
Well, did you in your declaration, sir, it was filed in this case, did you tell the court in that declaration
Fanny,
that the expenditure that you had provided on behalf of Ms. Willis was paid for back by her in cash, yes or no?
I believe that I did when I said that the expenses were split roughly evenly.
If you could point to me any place in your affidavit where you used the word cash, I would appreciate it. Take your time.
I didn't use the word cash, no, sir.
No, you didn't use the word cash, did you?
But I didn't say that she didn't give it to me in cash.
No, you just didn't tell anybody that you allegedly got paid back in cash, right?
No, I told everyone who asked.
Today?
Yes, sir.
Now, who else was with you, if anyone else, when you and Ms. Willis were discussing how you would be handling the financial component of the motion here today, that is the personal benefits?
I'm going to object to the relevance of that, Your Honor.
Mr. Gillen?
Well, the relevance is if they know that they're going to be called as witnesses, they've been subpoenaed, and they are discussing what they're going to say, we need to know that. The court needs to know that. It goes to the veracity of Mr. Willis and, Ms. Willis and Mr. Wade.
Overruled.
We didn't discuss how we were going to handle testimony.
My question was, when you were discussing with Ms. Willis in the conference room, when you were discussing what you perceived to be the situation concerning the benefits for the payments.
Yes, sir.
Was there anyone else present?
No, sir.
How long did the meeting take?
Probably 5 or 10 minutes.
Did Ms. Willis tell you what she was going to say?
No, sir.
Did you ask her whether she had any bank withdrawals that would corroborate the assertion that she would pay you back in large sums of cash for these trips to the Caribbean, Belize, California, on and on and on?
Your Honor, again, I object. The proffer, when the last relevance objection was made, was that Mr. Gillen needed to know who else was there. These could be potential witnesses that he could cross-examine. That question has been answered, so I wouldn't object.
Okay. I think it's still exploring possible bias or motive to shape his testimony. So overrule on that ground.
Thank you. Now, Mr. Willis, Mr. Wade, when you were having this discussion, did you ask Ms. Willis, do you have anything to support these cash withdrawals?
No, sir.
Did you ask her where she got the cash?
Here, this is the conversation. I produced my credit card statement that showed what Ms. Merchant in her filing was representing. That was the conversation.
Okay. So when she would pay you back in cash, were you aware of what her financial situation was? Do you know what?
No, sir.
Your Honor, I object to the relevance.
Well, Your Honor, it's relevant because we've been bombarded with the book, Find Me the Votes, in which...
What's at issue is the financial benefit, and if that plays a material interest in an actual conflict of interest. So I think that's relevant.
Thank you. Now, have you read the book, Find Me the Votes?
I have.
You have?
I have.
Okay. Now, in that book, Ms. Willis is telling the authors about how financially destitute she was, or kind of hitting down on the bottom as she was running for DA. Do you remember that part of the book?
So let me qualify the response. I've read the book in parts. I hadn't had the time to sit and read the book in its entirety.
Did you read that part about how she's telling the authors about how little money she had and how financially she was in bad shape prior to when she was running? Did you read that part?
No, sir.
Did you ever have discussions with Ms. Willis about her financial situation, which was in apparently in rough shape prior to her being elected DA?
No, sir. Ms. Willis made it clear that her financial business was just that. It was her business.
Wait, nah, no way, nah. He expects everyone to believe that he's with this woman who ran for office, was in financial straits, had a very difficult time. One, she is with him, they're romantically involved, doing... Okay? And for her not having money or in financial straits has never come up, and because it's her business... No. No. I don't care if a woman is low on money and she is really struggling, she's going to ask her man or let her man know. I don't care how strong she is with the sisterhood. No. Oh, man.
Nothing about her financial status. I know nothing about how she was faring before or after the election, or even now. I know nothing about her finances.
You're telling us that she didn't share that with you, but chose to share it with the authors of a book that's been published and printed and sold nationally.
I think that's a fair question for Cross.
I don't know that she shared it with the author. I don't know that the author is telling the truth. I don't know the author, so I don't know, sir.
Okay. Now, did you give an interview to the authors of that book?
I've given no interviews, sir.
So you haven't talked to them at all, correct?
I haven't talked to any media.
All right.
None.
Now, as it relates to the...
I'd like to, though.
As it relates to, again, from your bank records that you're aware of, there'll be no cash deposits, right?
I didn't say that.
Are there cash deposits which line up with the money that you have allegedly received from Ms. Willis to, quote, pay you back for her part of the trips?
So here's the thing. In my bank records, you will see cash deposits. You will see check deposits. I can't say that you look through the bank records and you won't see cash deposits, because I have two sources of income, sir. Income comes from my private practice, my firm, and income comes from the contract here with Fulton County. During the course of private practice, occasionally I will have occasion to deposit cash into my account.
And in preparation for this hearing and your testimony, did you go through your bank records to find out if you could locate any cash deposits that would corroborate your testimony?
No, sir. I didn't go through my bank records at all.
Now, so what you would do, the money that you received, of course, the money that you received from your work for Fulton County, that's public funds, correct?
No, sir. That's private funds. It's my
Public funds pay you to do work for Fulton County, correct?
Tell me what the definition of a public fund is.
A public fund
The people.
would be funds, as in not fund, but funds, money. Public money, as in money from taxpayers, either in Fulton County or the state of Georgia, pay you to do the work that you're doing here in this case, yes or no?
One or the other, I'm certain.
You know which
is
one?
the case. I don't know which one, no, sir.
Now, you would take those public funds, and those public funds were then used, deposited in your account, and they were then used to pay on the credit cards for the trips that you would take with Ms. Willis, correct?
I object to the question insofar as the characterization of public funds. The witness didn't testify to that, and I don't believe there's been any evidence to that. Once it's paid to Mr. Wade, it's private funds.
Well, the point of it is that you got
All
money.
right, Mr. Gillen's rephrasing.
Yeah, I'll rephrase. Let's break it down. You got money from Fulton County for the work that you do here, right?
Yes, sir.
You would send in invoices, and they would pay you money, correct?
Yes, sir.
Those money, that private money, that money was money from either the citizens of Fulton County or from the state of Georgia, correct? That's what I mean by public funds. Agreed?
Well, I guess I'm having trouble with the notion that the citizens of Fulton County have paid me any funds. I'm not certain the funding source. I can tell you that either the state of Georgia or Fulton County has written me a check.
So,
oh, come on. Oh my, look, you know that you know, Mr. Wade, that you're getting paid from the state and the county. And you know that how they generate the money is from the taxes of the people. So when you sit there and say, well, I don't know what they get their money from, you're so disingenuous. You're lying. Okay, I'm done.
that would be, those two entities are public entities, correct?
Yes.
So that would be public funds, right? Right? Yeah.
Yes.
And those public funds are from the same source that you would then use to pay out on your expenses for the trips that you took Miss Willis on, correct?
No, sir. As I testified to moments ago, I have income coming in from my law firm. I also have income coming in from the funds that we're here discussing now, from either the state of Georgia or Fulton County, and or both. I'm not certain what it is. So to say
Sorry,
that
I didn't mean to
that
cut you off. Go ahead.
So to say that I'm paying a credit card statement with funds coming from Fulton County or the state of Georgia would not be an accurate statement, because the funds could have very well come from my private practice.
What percentage of your income in 2022 came from money where you're working on this case, or from your partners working for the Fulton County office?
In 2022, I would say 50-50.
You think 50-50 in 2022?
Yes, sir.
What about 2023?
Probably 60-40.
60-40.
Yes, sir.
So the money that would be in those accounts, at least 60% of those, in your view, would be public funds, that those monies were then used to pay for the expenses that you had incurred for the trips that you took Miss Willis on, the cruises, the Napa Valleys, the Bahamas, correct? Right?
Yes, sir.
Okay. And now, what you did is that when you signed on in November 1st of 2021, that's when you signed on to be counsel for the anti-corruption matters, right?
Yes, sir.
Now, as you know, in your engagement letter, it doesn't say that you're signing on and your scope of work is to work on the Trump special grand jury investigation, does it?
No, sir.
It says that you're signing on to work on anti-corruption, the anti-corruption unit matters, correct?
Yes, sir.
Matters with a plural, correct?
Yes, sir.
So in your contract, there is no specific reference to any specific case. Isn't that right?
That's correct.
Okay. Now, but you didn't sign on for the duration. There was a period, you'd have a contract, and then it would then expire, and then you would have a new contract, correct?
Yes, sir.
Now, of course, the extension that you received, the first one was in November of 2021, and then you filed, or excuse me, there was a renewal in November the 15th of 2022. Is that right?
Sounds right.
Oh, okay. Now, that was right after you got re-upped by Miss Willis, right after you took Miss Willis to Aruba. Isn't that right? On that November the 1st, 2022 trip to Aruba, and through November the 4th, 2022. Correct?
What does re-up mean?
Well, re-up means that you came back, your contract was up, and then on November the 15th, you and Miss Willis signed a new contract for you, right?
Yes, sir.
Okay. Now, when you were in taking her to the Aruba and on the cruises and the resort there, did you discuss your re-upping of signing an extension on your contract?
No, sir. But you make an excellent point. I'm glad you pointed that out. So the trip to Aruba, the contract was not in existence then.
No, you're saying that you were not
under contract.
In your contract, did you send any invoices in for work that you did after your first contract expired?
No, sir.
You didn't?
No, sir.
No. When that expired, that was it. So then you're saying that after the Aruba trip, you get re-upped with a new contract, correct?
I signed a new contract, yes,
now,
sir.
Was there any modifications on that contract? Did you get an extension on the cap that you were limited on the first one? Were there any modifications at all, Mr. Willis? Excuse me. I've done that again. I apologize.
I've been called worse.
Wait, I'm sorry.
I've been called worse.
Now, were there any modifications on that?
Do you have the contracts in front of you where you could?
I don't have it in front of me, but I think that
because I believe as the work gradually, as the time of the work gradually increased, the hourly cap would increase. In other words, starting out the investigation, it was impossible to anticipate the level of cooperation during the course of the investigation from some of the witnesses. So if you assume that there would be great cooperation with the witnesses in terms of interviewing and speaking and being voluntarily speaking with you, it doesn't take as much time. So after getting into it, realizing that most of the witnesses were not willing to speak or willing to turn over evidence or information, quickly you figure out that this is going to take a little more time than originally anticipated. And because of that, you have to compensate for those hours.
That's why there was a compensation on your extension?
Yes, sir. The caps.
A cap. Now, did Mrs. Willis, did Miss Willis review your invoices with you when you would submit them?
Never.
Did anyone ever question whether or not you worked 24 hours in one day and billed 24 hours in one day?
I've never worked 24 hours in one day and billed 24 hours in one day.
Okay.
And I'm glad you asked me that question because I'd like the opportunity to talk about that.
I think you should go ahead.
So, if you look at that invoice where it says 24 hours in one day, it actually doesn't say one day. If you look at the top of the invoice, it says date completed. The date that's reflected on that invoice reflects the date that the work was completed. It doesn't say when it started. It just says this is the date that is completed. So if you go through the invoices, probably around the first 5 or 6, you'll see that that's the billing format. I would bill only after that particular task has been completed. That's why you see a 24-hour period with the one day there. I kind of wish some of the experts who had opined on that had called me and asked me the question, but there was never a billing of 24 hours in one day. Now, probably around the 6th or 7th invoice, you see the format changed. I started using a range so that it got less confusing, right?
I'm confused, so maybe you can correct it.
Okay.
In Exhibit 14, you've got down a specific day.
Mm-hmm.
Prepared cases for pretrial, November the 5th, 2021, 24 hours at $250 an hour, 6,000. No, this wasn't about a range. It was about the work that you did on November the 5th, 2021.
No, Mr. Gillen, look at the top of the invoice where it says date completed.
Yeah, what I want you to do, Mr. Wade, is focus on the date that you have down there and tell the court what you billed for on November the 5th, 2021. I thought it was already in. I thought 14 is in.
Again, Mr. Gillen, it says completed date completed. The dates that you see here are the dates that work was completed. So on November the 5th, I completed the task of preparing the cases for pretrial. That's the date I completed it.
Just read, if you would. Then my question was, read out loud the entry for November the 5th, 2021, and how many hours you billed that day. Just do that for me, if you would.
I can't do that.
Excuse me, I believe the witness is entitled to answer his question. That certainly wasn't the question that Mr. Williams asked.
All right, well, the question now is to read a certain entry.
Okay, I get exactly what he's saying. And the lawyer's trying to trip him up to box him into saying, you did all that work on that day. You billed 24 hours on that day. And he's saying, no, that's the day when all the work was completed. So if he did work in June, 15 hours in June, 5 hours in July, whatever it is, he added all that up and said it's all completed on that day. I gotta say, this lawyer, he's doing a little shady stuff, but so is he. And I don't know if his license is on the line, but it doesn't look good. But then again, I'm not a lawyer. Nope.
Just read into the record, Mr. Wade, on November the 5th, 2021, how many hours did you bill the citizens of Fulton County for on that day? Just read it out, please.
I completed the task on November 5th, 2021. 24 hours was billed at $250.
Completed. The main word is completed.
Now, when you talked about your relationship with Ms. Willis, and your testimony is that it began in 2022. Do you remember that testimony?
No, sir. Our relationship began in
Your romantic
2019.
relationship began in 2022? Is
Yes,
that what-
sir.
That's
Yes,
your
sir.
testimony?
Yes, sir.
Okay. Now, when you were re-upped on this contract, you had a romantic relationship already established with Miss Willis, yes or no?
In 2022?
You know, when
Yes,
you were
sir.
re-upped on November the 15th, 2022, you had a romantic relationship with Miss Willis.
I signed the second contract. Yes, sir.
Answer my question, please.
I'm not going to use the words re-up.
Signed up on the we re-up or whatever you want to call it, your contract on November the 15th, 2022, you had a romantic relationship already existing with Miss Willis, yes or no?
I signed the contract, the second contract, yes, sir, during the course of a romantic relationship.
Yes or no, you had a romantic relationship with her at the time that you signed up the extension on November the 15th, 2022, yes or no?
The answer to that question is yes.
Thank you. Now, this was before the special purpose grand jury released any report. Isn't that correct? Correct?
Are you asking me if it's before the work was completed or before the special purpose grand jury actually publicly released the report?
When they
Those are
released
two
the
different.
report. Your relationship with Miss Willis already existed when the special purpose grand jury released its report, correct?
At the time the report was released, yes, sir. But
And-
you understand that the report, the work had been completed prior to the release of the report. You understand that?
And your relationship with Miss Willis, of course, was prior to the indictment in this case, correct?
Yes, sir.
Your Honor, if I may just ask my folks over here whether there's anything I need to clean up on. That's all the questions, Your Honor, I have. Thank you.
Your Honor, I do have questions.
Well, Mr. State, I think we went through.
I think he did better than a woman.
The permission, he was going to go first.
But he did hold his own. He did stumble. Yeah, his wife is.
That's what I thought I had asked for.
All right, with the understanding next time, we're going to keep going in order and not skip around the order. All right.
That's why I brought it up, because I thought that's what.
Okay. All right. Mr. Sato.
I'm going to try to keep my questions very specific.
Yes, sir.
Okay?
Yes, sir.
And I'm going to also, of course, try not to go back into specific questions that have already been asked. Okay?
Yes, sir.
When did your relationship with Miss Willis end?
2023.
Can you give us an approximation of, not by date, but by month?
Summer 2023. Forgive me. I'm a man. We don't do the date thing. Summer 23, I would say June, maybe.
Okay.
With women, with women, we know the exact date, time, what the weather was the wind blowing, what he said, how he said it. We remember all that. So yeah, I give it to him. Okay, I'm a little hard on him. Yes, I am.
Using the euphemism personal relationship, did you have any personal relationship at all with Miss Willis after the summer of 2023?
I want to make sure that I'm answering your question. Are you, because
let me rephrase, if I might. The way it has been characterized in, for example, the response of the state, and I believe in your affidavit, is there's a difference between a personal relationship in a professional relationship, correct?
Yes, sir.
Okay. I'm not talking about a professional relationship. I'm talking about a personal relationship. Have you had a personal relationship at all, and you know what I mean by that, after the summer of 2023?
Are you asking me if I had intercourse with the district attorney?
I was trying not to, but I guess if you're going to characterize it as that, the answer would be?
The answer would be no.
So it's been purely professional since the summer of 2023.
So that's where we're having issues.
Okay, you'll have to explain because I don't know what the issue would be.
No, I will explain to you.
Thank you.
You say personal. We're very good friends, probably closer than ever because of these attacks. But if you're asking me about specific intercourse, the answer is no.
How about if I change it from intercourse to romantic?
No.
Okay. During the direct examination, you made a statement, at least I believe I heard it correctly, that you, personal relationship, and now I'm talking about that characterized the sexual romantic relationship, was not a secret. Is that correct?
Wait. If you're asking me if people knew that we were having sex, no, they didn't.
I'm asking you whether the people knew that you were dating, whether you were romantically involved. You said that it was not a secret.
Oh, it wasn't a secret. It was just private. My mother knew, obviously.
Okay. Did anyone in the district attorney's office that has worked on this case know that you were dating or had a romantic relationship with District Attorney Willis?
I don't know what they knew.
Well, did you tell anyone?
No.
Do you have any knowledge of whether Miss Willis revealed it to anyone?
I have no clue.
Okay.
She told everybody.
So as far as you know from personal knowledge, no one in the DA's team knew, correct?
That's correct.
Okay. So if it was a legitimate...
Okay, wait. Okay. He may not have told anyone, but she did. Girl, I'm over there dating. Oh, I'm over there dating Nate Wade's. Oh man, he is a tall drink of chocolate milk. Blah 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 blah. Her mouth did this. Just yap 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 yap. But she's private. No, she told her former colleague that she fired or made her resign. Okay. Oh, and she's still bitter.
Relationship. Is there any particular reason why it was kept secret or private?
It wasn't kept secret. It was kept private.
And the purpose for that was?
It's what we chose to do.
I'm asking you why, though, not just because you chose. Why, if you're dating someone, why keep it private?
So, a few reasons. The first one is, and I want to say this respectfully in the right way, there are some people who are in the public eye who just don't like it, don't wish to be there. I have tried to have lunch or dinner with her publicly, and I can't count the number of people that would approach the table or would accost us as we're trying to walk into a restaurant and just have lunch or have a meal. It is not secret, it is private. We don't want the world asking questions or interrupting that time. So we weren't trying to keep anything a secret, Mr. Sadal. There's nothing secret or salacious about having a private life. Nothing.
I'm not suggesting that there was. I'm asking the questions. When you went on the various trips that have been outlined by both Mr. Gillen and by Ms. Merchant, did anyone in the district attorney's office know that the two of you were traveling on personal trips together?
To my knowledge, Mr. Sadal, no.
Okay. And again, that was for privacy, according to your testimony.
Privacy, yes, sir.
Okay. Did you and Ms. Willis go to the Hapeville condo prior to your relationship starting the beginning of 2022?
Prior to having physical contact, prior to having intercourse? Did we go to the Hapeville condo?
Again, you keep going to intercourse. I'm trying not to, but fine. The answer to that, or my question would be yes. Did you and Miss Willis go to the Hapeville condo prior to what I want to say November 1st of 2021?
Yes.
Okay, and the purpose for going to the Hapeville condo with Miss Willis prior to 2021 would have been what? Or prior to November 1 of 2021?
Could have been any number of things, because at that time...
That's what I'm asking, so tell me.
Yeah, could have been any number of things, because at that time, she had a friend living in that condo. Miss Yerdey lived in that condo.
Okay. So, it maybe was my question was poorly worded. Let me try again. Your answer is yes, prior to November 1st of 2021, you would have gone to the Hapeville condo and been there with Miss Willis, correct?
Yes.
And you would have been there, as you indicated, for many reasons, right?
Yes.
Can you give me, just list a few of the reasons?
Miss Yerdey resided there, went to visit her, maybe went to talk about a document that I received.
You would go to the condo to talk about a document that you received?
Absolutely.
Okay, go ahead.
Absolutely.
Any other reasons?
None come to mind.
None come to mind?
No, sir.
And would you say that was frequent? When I say frequent, do you think prior to November 1st of 2021, you were at the condo more than 10 times?
No, sir.
So it'd be less than 10 times?
Yes, sir.
So if phone records were to reflect that you were making phone calls from the same location as the condo before November 1st of 2021, and it was on multiple occasions, the phone records would be wrong?
If phone records reflected that, yes, sir.
They'd be wrong?
They'd be wrong.
Okay. Where did you live during that time period?
The same place I live now.
Which is not in Hapeville, correct?
It is not in Hapeville.
It is north of Atlanta, the city of Atlanta, correct?
It is.
Okay. And any other reasons why you would be in the Hapeville area on multiple occasions prior to November 1st of 2021?
Let's see. The Porsche experience is there.
I'm sorry?
The Porsche experience is there.
Okay, so that would have been one. Any other reason?
Yes, sir. The airport is there.
Airport in Hapeville.
Yes, sir. Delta Airlines is headquartered there. Let's see. Restaurants there.
Okay.
He's trying.
If that's your recollection, that's fine. I'm not asking you to try to remember everything, but if that's
okay.
Okay. Did you discuss your affidavit filed in connection with the response with Miss Willis?
No, sir.
Did you know, personal knowledge, whether Miss Willis reviewed your affidavit before it was included with the response?
I have no clue.
So, as far as you know, personal knowledge, Miss Willis did not know what you said in the affidavit.
I didn't give it to her.
That's what I said. You have no personal knowledge.
No personal knowledge.
And as far as you know, no one else has told you that she did or didn't.
I hadn't asked anyone.
We've kind of worked this up a little bit, and the numbers could be off. But according to our numbers, $10,000, give or take, would have been reflected on your credit card statements in connection with things of potential benefit to Miss Willis, okay? I want you just to assume that. Assuming that there was $10,000 that you had on your credit cards, is it your testimony that Miss Willis paid you back $10,000 in cash? I'm not asking about...
Can I object? The characterization of $10,000 for Miss Willis's travel, I don't believe is an accurate reflection of what the numbers, at least the summary that I've been provided by the defense, would reflect. I think that's joint travel. Is that right, Mr. Sater? I'm sorry.
No, it's not joint travel. But all I'm trying to understand, I'll rephrase because I don't want to get bogged down on specific numbers. You would have received thousands of dollars in cash from Miss Willis, correct?
Yes, sir.
Okay. and the thousands of dollars in cash from Miss Willis, do you know, I'm not asking you whether she took it out of her pocketbook or she took it out of a suitcase. I'm saying, do you know the source of the cash?
Just that, out of her pocketbook. Yes, sir.
You don't know where she obtained the cash?
I didn't ask her.
And the whole time that she was paying you in cash, you never said, hey, why do you have this amount of cash?
Why, Mr. Sadow, in my practice, people come into my law firm all the time with cash. I never question where they got it.
Yeah, but we're talking not about people that come into your law firm. We're talking about the district attorney of Fulton County, who I'm assuming receives a paycheck. She doesn't get paid in cash.
So just like you assumed, I assumed she got it from her paycheck. I don't know.
Okay. But of course, it's already been, and I'm not going to go back into it. You've not seen any records indicating withdrawals of cash from Miss Willis at all.
Why would I ask her?
I didn't ask.
Sir.
All I said is you haven't, right?
No, sir.
Okay. Now, can you explain why you filed for divorce one day after you were hired by Miss Willis? You filed on November 2nd of 2021. You're hired on November 1st of 2021. Why the day after?
You mean one day before? So
you filed for divorce one day after you were hired, right?
Okay. I'll answer your question.
Okay, please.
So in 2015, when my wife had the affair, we had a conversation that we would divorce right then. Again, the better practice, at least for my children at the time, was to stay in place until the youngest could graduate and matriculate into college. We did that. When she graduated, matriculated into college, at the time my wife had moved back and forth to Houston, to Texas. So she's in Texas. We take our child off to college. We come back to Georgia for a brief period of time. Divorce gets filed. She gets served. There we go. Now, the reason that date was selected.
Yes, sir. That's what I asked.
The specific reason that specific date was selected was because she was only in town for a brief.
Your Honor, this is attorney-client privilege. Why he decided to file this.
And why do you have the right to object on his behalf for attorney-client privilege?
Because.
Well, I don't make a formal objection.
All right, there we go. And
I believe that he's already attempted to answer this question, and there was no privilege raised. So he's given a partial answer, and now he's about to finish that. So first of all, I don't think it's covered by attorney-client privilege, and I'll deal with that if you want me to. But otherwise, he's already answered part of it. So he doesn't get to say, now I'm going to stop. So.
Well, it was a long preface, but I don't think it ever actually got to what might have been at issue there. So if you can lay the foundation, we'll deal with the objection.
Okay. Take a step back. Okay. You realize that an attorney-client privilege is the privilege of the client, correct?
Yes, sir.
And you, in connection with your representation, at least it's been proffered to the court by Mr. Bradley, that it's up to you to decide whether you want to raise the privilege, right?
Yes, sir.
It's not up to Mr. Bradley.
Yes, sir.
So you have the power, in order to get to the truth of the matter, you have the power to waive the attorney-client privilege, do you not?
I believe that's an appropriate question. The privilege is there.
Whether he uses it or not, it doesn't matter why. Mr. Sadow, I think if we're trying to get to the answer to your question, let's figure out whether it covers the question you were trying to get to.
And if I may finish, and your position is you have no intention of waiving your attorney-client privilege, correct?
That's correct.
All right, so now, can you answer the question why you waited until November 2nd, the day after you were hired by Ms. Willis, to file for divorce?
I can.
Okay.
So, again, Joycelyn had relocated to Texas, and she had been in Texas for months. She was only here for a brief period of time to drive my daughter's car back with her. And when she came here to do that, I was able to then get her served.
Okay, so your answer as to why you waited until the day after you were hired by Ms. Willis, which would be November 1st, 2021, to file the complaint for the divorce on November 2nd, 2021. Your testimony under oath is because your wife was here. But had not been here in October, had not been here in September, had not been here in August of 2021.
She had been in Texas taking care of her ailing mother and
your testimony...
an aging father. So the first opportunity that I had after speaking with my lawyers to take care of that was the date it was filed and served, because she happened to be here. It had nothing to do with, that was purely coincidental, that contract.
I understand it's purely coincidence, your testimony.
Yes, sir. And understand that this was by agreement between she and I, she being my wife and I, that we would divorce when the children matriculated out, and that there would actually have been an agreement attached to the filing. It became apparent that the agreement wasn't going to happen, and things got a little contentious. So that's when the privilege will kick in, and I was forced to do it when I did it.
So, if I understood correctly, again, you tell me if I'm wrong. Is it your testimony that your wife was not in Atlanta, Georgia, or the metro area throughout October of 2021?
No.
That's
In
not your
October,
testimony?
in October of 2021, she was back and forth between here and Texas.
So she was, at least on some occasions, in the Atlanta area.
But that was during the time when we were working through the consent agreement that fell through.
Again, I think we're pretty far afield on relevance. The answer to the question about the timing of the divorce filing.
Understood, Ms. Cross. Ms. Sato, where are we going from here?
We're about to finish this area, since I'm not going to be able to go any further about, if we want to call the X, we'll call the X for that purpose.
Well, we might have to discuss whether that's a collateral issue altogether.
No, I'm just saying if. I didn't say we will, but we'll.
Okay.
All right, so you said that you were aware of the contracts that Mr. Bradley and Mr. Campbell had with the Fulton County District Attorney's Office, correct?
Yes, sir.
And how did you become aware of those?
Just through conversation. They
With
told
who?
me.
Conversation with who?
Mr. Bradley and Mr. Campbell.
So you were discussing matters with Mr. Bradley which were not related to attorney-client privilege, correct?
Related to the contracts, yes.
Okay, but you were having conversations that would not, even though, if I understood correctly, Mr. Bradley was your attorney at the time, correct?
At what time?
At the time that Mr. Bradley received his contract from Fulton County, which would have been beginning of January or in January of 2021, right?
Is that the date of his contract?
Pretty close.
I don't know what the date of his contract was, but if it was after the date of the filing of divorce, then yeah.
I'm not talking about after the date of the filing of divorce. It's been represented to the court that you had an attorney-client relationship with Mr. Bradley from 2015 forward.
Yes, sir.
Correct?
Yes, sir. That is correct.
When Mr. Bradley received his contract with Fulton County, that was in 2021, correct?
I don't know.
We can prove that through other evidence. But at the time that Mr. Bradley was doing work for Fulton County, if I understand, you still had an attorney-client privilege, at least you're claiming one, with Mr. Bradley, correct?
Yes.
Okay. So when you talk to Mr. Bradley about matters with his contract in Fulton County, those were not covered by your attorney-client privilege, correct?
They were not.
Okay, and that meant that not all communications with Mr. Bradley were covered by attorney-client privilege, correct?
Well, those certainly weren't.
Well, but my question was, not all communications with Mr. Bradley were covered by, at least as you've been represented to the court, by the attorney-client privilege, correct?
Those communications were not.
So there were communications outside of the attorney-client privilege, correct? With Mr. Bradley.
If you're asking me if I ever communicated with him outside of the attorney-client privilege, the answer is yes. I've
Okay.
communicated with him outside the attorney-client privilege.
Let's finish this up. And did you call it Roman number 4? Which is defense. Okay. In defense exhibit number 4, and Mr. Gillen went over with you your responses to certain interrogatories on May the 30th, 2023. Remember that?
Yes, sir.
Not going back into those, the words in the interrogatories are already in evidence, so we're not going to do that. But the ones that we've gone into, there were 2 of them. And your answer to both of those was none, correct?
Yes, sir.
Okay. Now, on January 25th of 2024,
yes, sir,
you again were in a position that you answered those same interrogatories, the 2 that we're talking about. I can get specific if we need to, but as long as we understand we're talking about the same 2,
yes,
right?
Sir. Yes, sir.
Okay. And they are in defense exhibit number 6, and they are interrogatories number 4 and number 5.
Okay. Go ahead.
No, I want you to be able to see it. So it's a defense exhibit number 6.
I don't.
Does he have 6 up there? I'm told that you have 6.
Okay. Here we are.
Okay. You would agree with me that in defense exhibit number 6, and we're talking about interrogatories of January 25, 2024.
Yes, sir.
That as to interrogatory number 4, that's the same interrogatory, same words that were in the interrogatory that Mr. Gillen went over, which was dated May 30th of 2023, correct?
Yes, sir.
And your original response in defense exhibit number 6 was none, correct?
Yes, sir.
Your updated response was the plaintiff declines to respond to this interrogatory and asserts his privilege pursuant to OCGA section 24-5-505, correct?
Yes, sir.
You know that 24-5-505 breaks down into two privileges, right?
Which is why I was specific. I said I asserted the privacy privilege.
Well, that's what I'm asking you. But in your updated response, there's no reference to privacy, correct?
Yes, there is in the code section 24-5-505.
Okay, but it also
reference to privacy.
Right. Just go with me, okay? That code section says, does it not? No party or witness shall be required to testify as to any matter which may incriminate or tend to incriminate such party or witness, or which shall tend to bring infamy, disgrace, or public contempt upon such party or witness. You'd agree with that, right?
I'm not reading it.
I'm sorry?
I'm not reading it. I don't have it in front of me.
If I may.
Ms. Seno, we can, I can take judicial notice that is what the rule says if you want to ask him any follow-up questions.
Okay, thank you. You are not claiming that your answer to number 4, interrogatory number 4, on January 25th, 2024, incriminates you, that is, as in Fifth Amendment privilege, right?
That's correct.
You're claiming the second part, that it would bring infamy, disgrace, or public contempt, correct?
I'm going to object to that. I don't think that's the full thing, but and also the witness doesn't have it in front of him, so I don't know how he could respond to that. He's said several times privacy is why he invoked that statutory.
Overruled.
I'm claiming privacy.
The privilege that you make reference to is to infamy, disgrace, or public contempt upon the witness, right? Or party. That's the section that you were relying on, correct?
Yes.
That's what it says, yes, sir.
Okay, look. I could show you, but I think the court has already indicated he can take judicial notice of the statute. So assume that what I'm telling you is accurate, okay?
Yes, sir.
Okay. How would an answer of none bring infamy, disgrace, or public contempt upon you?
So, as I explained in direct of Mr. Roman's counsel, the minute she elected to intervene into my divorce proceeding, I then started to understand the bigger picture, which was that all the attorneys in the election interference case were colluding with Joycelyn's divorce lawyer. And because of that, I said, privacy. I don't want my divorce proceeding to bleed into this criminal proceeding. I just didn't want that.
So you raised a privilege, if I understand, that indicated that your answer would bring infamy, disgrace, or public contempt upon you, right?
Your Honor, I'm going to object to the relevance of this. It's been asked and answered several times.
Mr. Seda, where are we heading with this?
I think I can finish that up by saying you didn't say none again. You asserted a privilege, correct?
That's correct.
Okay. And you did the same thing, did you not, with number 5?
That's correct.
That is, you didn't say none again, right?
Correct.
Okay. Is the answer to the interrogatory number 4, as you have it in front of you, is the answer none? Is that the truth?
The answer is, to that interrogatory, is as I placed it at the time I responded, sir.
I'm asking you now, is the answer to that interrogatory none?
The answer is still privilege.
All right. So he's apparently electing to apply the same privilege, Mr. Seda, to that exact same question.
And I have a case which indicates that we can get beyond that if the court deems that appropriate.
And to what end? To what end? Where?
That the privilege actually does not apply and he must answer the question.
And where does that get us? Even if he answers the question, hasn't he already kind of said everything he has to say about the nature of the relationship, how long it lasted, when it ended?
No, I think it would prove. I think if he is forced or compelled to answer the question, he will either answer it falsely by saying none, or he answers it truthfully by saying yes, and then telling us what it is. That's what I believe. That's why I'm asking.
But the interrogatory you're referring to, though, the question contained there.
Two interrogatories, yes, sir.
It's the entertaining one. It's whether there were other relationships, right?
With a specific language that's in the interrogatories.
Sure. Haven't you already covered that in all the other questions that we've had so far?
We have, but again, the court could, if I could require or compel an answer from him as to whether his answer would still be none, then we would know whether or not he was telling the truth. Now, if the answer is no, then obviously there was a time in the past where he was not. It simply requires him to now answer under oath what he refused to answer and claimed, but I might suggest it's a bogus privilege, and that you can pierce that privilege because it's a material fact in connection with this case. Again, it's a call that Your Honor makes. I have case law that says you can do that, but it's your discretion.
Ms. Cross?
Your Honor, Mr. Bate's been on the stand now for several hours. He's asked and answered very personal questions that I believe cover the issues. Mr. Seda was making argument, and this is probably an argument to make for the later to the court and not a question to propound to it.
So as I see it, the only relevance these interrogatories have to this case really whatsoever would be as either prior inconsistent or consistent statements. And to that end, I think the question has been put to him again and again and again. He's answered how he believes he felt his answer should be and why he answered a certain way. And as it goes to credibility, I think at this point we're arguing weight, and I don't really see the value in pushing this issue further. So,
all right. Well, just for the record, the case that I was going to refer to is State versus Wakefield at 324 Georgia Appeal 587, and specifically, let's see, it would be 590, in which they talk about this specific privilege. This is a 2013 case. And then they footnote to footnote 3. And footnote 3 says, there are times when the materiality of the evidence outweighs the testimonial privilege. And it goes and explains what that is. That's what I'm bringing up.
And I see what you're saying, that we could say that you need to answer the question regardless of the privilege you asserted. At this point, though, I think we've covered that ground and we're ready to move on.
Okay. Based on that, I have nothing else. Thank you.
Okay. Mr. McCulloch? Anything? On behalf of Mr. Floyd. Moving through defense counsel.
Oh, I'm sorry.
No, I'm looking behind you. Mr.
so,
McCullough.
okay.
On behalf of Mr. Floyd. He's elbowing you, sir. Okay. Mr. Cromwell.
Nothing, Your Honor.
All right. Ms. Cross.
Thank you, Your Honor. Mr. Wade, have you still got exhibit number 14 in front of you? The one with all of the invoices, I believe.
I believe I have them all.
All right. So you were asked, Mr. Wade, about a couple of the invoice items. And your testimony, I think, was that the percentage of income post special counsel appointment in November 2021, the percentage of your income roughly after that time was about 50-50 Fulton versus other income from your law practice, correct?
Roughly, yes, ma'am.
Okay. Sometimes more, sometimes less?
Yes, ma'am.
All right. How about your time? I'm interested in the percentage of your time from November 2021 to, let's say, the close of the special purpose grand jury when it was dissolved in January 2023. Can you estimate for us the percentage of your time that was spent on Fulton County work versus other work?
Oh, gosh. 99% of the time here in this building working on this case.
All right. It was, as I understood your testimony, it was an intense period in terms of hours while that special purpose grand jury was meeting, correct?
Yes, ma'am.
And who was head or manager of the election integrity case during that time for the district attorney's office?
I was.
You were coordinating the efforts?
Yes, ma'am.
And those efforts included not just the proceedings that were happening in this building, correct?
That's correct.
You don't need to go all through it, but is your representation that 99.9% of the time, let's restrict it to 2022, 99% of your professional working time was devoted to this case?
Yes, ma'am.
And the remainder, whatever it was to some of your other cases that were ongoing?
Yes, ma'am.
All right. 2022, I want to focus on that a little bit because if we are looking at, I believe, the financial affidavits, do you have those in front of you as well?
I do.
The financial affidavit that was filed in your divorce case in January 2022, you estimated your monthly income at that time was $14,000 a month, right?
In 22?
January 22.
Yes, ma'am.
January 23, what'd that number come to?
9,000.
What about 2024?
I don't know.
Is that there in front of you? Is that one? That's not one of the ones that's there in front of you?
No, ma'am.
All right. So as reflected in those financial affidavits, your income decreased as a result of your work in this case, correct?
Significantly.
The structure of your firm, we talked a lot about that, and I don't want to go through it anymore, but than we need to. But 2022, the structure of your firm changed. Is that correct?
That's correct.
Right. In the early part of 2022, there were three of you. You and Mr. Campbell and Mr. Bradley, you split expenses, is that right?
That's correct.
And you profit shared among yourselves, correct?
Correct.
Right. After Mr. Bradley left the firm, then there were just two of you, correct?
That is the cause of the significant change. Yes, ma'am.
So now you have two people bringing in income, correct?
Correct.
And one of those people, you, is spending almost all of your time devoted to this election integrity case, correct?
Yes, ma'am.
Right. And your income from this election integrity case is less than what it was the year before.
Yes, ma'am.
We talked about the monthly caps, or we didn't talk about it. There was talk about the monthly cap that was included in your contracts, indicating there was a certain threshold that you could reach, number of hours a month, and over that amount you were not going to be compensated, correct?
That's correct.
All right. And you kind of smiled when you said that. That's a little bittersweet there, isn't it?
That's bitter.
All right. Exhibit 14, is that still there in front of you?
It is.
I want you to take a look, please. That's a collection of exhibits that includes all of your invoices, as was represented. I want you to take a look at invoice number 9.
Yes, ma'am.
Is that there in front of you?
I have it.
Invoice number 9, Mr. Wade, indicates that you performed hours of work that you were not compensated for because your cap had been reached.
Yes, ma'am.
I want you to take, and what did you do in those circumstances? When the hours that you worked per month were more than the cap that was in your contract that you were permitted to be paid for?
I was forced to lose that time. I didn't get paid for it.
Okay. And that's what exhibit number 9 shows?
Yes, ma'am.
All right. And in exhibit number 9, you've got a task, hours that were completed, and you just didn't bill for it. You noted the time and then a 0 beside it because you didn't bill the county for that time.
Yes, ma'am.
All right. What about exhibit number, invoice number 13? Can you flip to that for me?
I have it.
Is that a similar situation?
Yes, ma'am, it is.
And what is it on invoice number 13?
This invoice makes me cry. There's so many hours here that I worked that I couldn't get paid for. So.
And you work those hours anyway, Mr. Wade?
Oh, absolutely. This is not the type of job that you could walk away from just because you're not getting paid for it. I think there's some professional rules of responsibility to an attorney who's engaged in a case. You have to see it through. So it's not like I could just throw my hands up and say, well, I reached my monthly cap, I'm done, I can walk away. I can't do that. This is ongoing, it's constant, and I have to do the work.
Can you look at invoice number 23 for me there in exhibit number 14?
Yes, ma'am.
Does that reflect a similar situation, the hours worked that you were not compensated for?
Yes, ma'am.
Invoice number 24 and 27, can you take a look at those and let us know if that reflects the same situation?
Are you trying to depress me?
No,
Look at the money I'm losing.
Okay.
It's the same, yes.
Okay. And there's no workaround to that? You didn't attempt to work around that contractual cap on your hours?
Oh, no, ma'am.
All right. You were asked a lot of questions, Mr. Wade, about the affidavit that was submitted, correct? Do you recall those questions?
I'm sorry, I'm stuck on this invoice. You know, if I was going to get a benefit, I'd like that benefit. That's the one I want. That didn't happen.
That didn't happen?
Okay.
All right. And there was no renegotiating your contract to reflect that those hours should be paid, right?
No, ma'am.
Okay. All right. Do you have your affidavit there in front of you?
I do.
The affidavit, of course, was attached to and provided in support of the state's response to Mr. Roming's motion, correct?
Yes, ma'am.
All right. And you prepared that affidavit?
I did.
You signed that affidavit?
I did.
All of the allegations and the representations in that affidavit are true. Is that right, Mr. Wade?
Every one of them.
Every one of them. You were asked a lot of questions about our line number 34. Can you turn to that for me, please? It's on page 4 of that affidavit.
Yes, ma'am.
Can you read it out loud for me, please?
The district attorney and I are both financially independent professionals. Expenses for personal travel were roughly divided equally between us. At times, I have made and purchased travel for District Attorney Willis and myself from my personal funds. At other times, District Attorney Willis has made and purchased travel for she and I from her personal funds. Examples of District Attorney Willis's purchasing plane tickets for she and I with her personal funds for our personal travel are attached.
Funds, Mr. Wade. As you understand the term funds, does that include cash?
Yes.
Does that include credit?
Yes.
Does that include reimbursements?
Yes.
You didn't represent in your affidavit, Mr. Wade, that you were including all of the receipts from funds or travel expenses that were paid on your behalf by District Attorney Willis, correct?
That's correct.
You had, I think your conversation with Ms. Merchant was you produced the receipt that you had.
Yes, ma'am.
Are you aware of any other receipts? Well, let me ask it this way. May I put you on the third stick? That's all right. I'm going to write it on there. I'm going to mark this as state exhibit number 1. You testified testify, Mr. Wade, that District Attorney Willis purchased and funded the entire trip to Belize. That was her treat to you for a birthday?
Yes, ma'am.
And you testified that she purchased the plane tickets for you, correct?
Yes, ma'am.
And while you may not have had the receipts on hand when you filled out the affidavit because they weren't in your possession, are you aware now that there are receipts and that it reflects that the district attorney...
If this is going to go into evidence, we'd like to look at it first.
I've got a copy. Do you remember, Mr. Wade, approximately how much, and that's again State's Exhibit number 1, may I question this now? Do you remember how much the flight was for you, your flight to Belize? And if you don't, I'm not tendering it for you. I'm just asking you to take a look at that and see if that refreshes your recollection as to the amount that that plane ticket cost that was extended by District Attorney. You may keep it. You keep it. Does that refresh your recollection, Mr. Wade?
It does, thank you.
Approximately how much was the amount of the ticket that District Attorney Willis purchased for your travel to Belize?
$887.35.
And I'm not tendering it, Your Honor, but I will leave it with the court reporter for reference. All right, Mr. Wade, your testimony here in court today and consistent with your affidavit was that the personal relationship, I think we've called it dating today as well, the personal or dating relationship between you and the district attorney began sometime in early 2022, March, I think was your testimony, is that right?
Yes, ma'am.
Right. And that March date isn't included in the affidavit. The affidavit is less specific, but that was your testimony today?
Yes, ma'am.
And that there was no personal or dating relationship prior to that time, right?
None.
Right. Mr. Wade, I'm sorry. I'm going to direct your attention to 2020. In 2020, were you dating the district attorney?
No.
2020, that was during the COVID pandemic, correct?
It was.
Was there a situation for you, Mr. Wade, that made you particularly vulnerable during the COVID period?
Yes, ma'am. In 2020, and a portion of 21, I was battling cancer, and that prevented me from pretty much leaving environments that aren't sterile, and I had health on my mind.
You were particularly cautious during that time.
Yes, ma'am.
Were you dating anyone in 2020?
No, ma'am.
All right. Thank you, Mr. Wade. That's all I have.
Ms. Merchant, recross on those points only.
Yes, thank you. All right, Mr. Wade. The state asked you about how much money you're making now versus before, and you said you're making significantly less since you've started working for Fulton County, correct?
Well, I did say that, but what we're talking about is because now at this point the splitting of the financial obligations in the firm are now there are two people carrying the weight of three, so that would scale back on the amount of income, right? Amount of profit.
Well, you're splitting the profits 50-50 though instead of 1/3, correct?
The profits, yes.
Okay. So, but you did testify that you're making significantly less now. We heard about it for a few minutes. Significantly less now that you work for Fulton County, right?
Yes.
Okay. Would you agree with me that $236,000 is more than $184,000?
Absolutely.
Would you agree with me that $262,000 is more than $236,000?
Absolutely.
All of these years, despite you saying that you were a three-way partner with Wade and Campbell and Bradley and now a two-way partner with Campbell, all of your corporate tax returns are filed in the law firm of Nathan Wade, though, correct?
My returns, yes, ma'am.
Yes, for your law firm.
Well, for my law firm, because I also have personal returns.
Right, and I'm not talking about your personal returns. I'm talking about your business returns.
Yeah, but the question contemplates that my bring home money is more or less. So I want to be clear that is reflected in my personal returns.
I didn't ask you anything about bring home money, though. I'm not sure what you're talking about.
What I'm talking about is your question was the portion of my testimony dealing with earning significantly less money.
No. My question is during, and I'll just break it down. During 2019, you filed your business returns. I'm not talking about your personal. Your business returns for the law firm of Nathan Wade only, correct?
I filed personal and business. Yes, ma'am.
And even though you said you were partners with Bradley and Campbell later on, you filed your business returns not with them, but as a solo practitioner, correct?
I see where you're going. There's a different return for that Wade, Bradley, Campbell entity.
And I'm not asking about that. What I'm asking about is during the years 2019, 2020, 2021, and 2022, you filed a business return for the law firm of Nathan Wade.
Yes, ma'am.
And in 2019, you said that the law firm of Nathan Wade made $184,000, correct?
No, I don't know.
Does that sound familiar? Does that sound about like what you made in 2019 and reported on your taxes as a business law firm?
If that's what's on the return, yes, ma'am, you're right.
Okay, and I'm happy I can bring those up. I've got one copy. I'm not planning on admitting them because they're tax returns, but okay. All right, may I approach, Judge?
Yeah.
Thank you. So in 2019, gross profit for the law firm of Nathan Wade is $184,000, correct?
Let's see.
The second line, number 2, gross profit.
Yes, ma'am. 184,824. Yes, ma'am.
Okay. And then in 2020, you also filed Nathan Wade, attorney at law, and your gross profit was $230,000, correct?
Yes, ma'am.
And in 2021, you also filed as a solo Nathan Wade PC attorney at law, and your gross profit was $236,000, correct?
Yes, ma'am.
And then in 2022, you filed as a solo practitioner Nathan Wade, and your gross income was $262,000, correct?
Yes, ma'am.
Okay. I'm not going to admit those since we've got your social. But nowhere in these documents do you document that you received cash payments from Ms. Willis, correct?
I don't. I hadn't looked through them. I would be surprised if there were something in there that said that.
Do you want to look through them?
Listen to the answer. I'd be shocked if there was something in there that said that I received some cash from Ms. Willis.
Okay. But there is itemized expenditures for travel in here. You did itemize that.
I didn't itemize anything.
Your accountant itemized it.
I hope so.
But you're responsible for your taxes, even if your accountant files them, right?
I agree.
And so you itemized your expenses for travel on all these documents, but you did not itemize. You didn't put anything in there about you being reimbursed for half of that travel.
Well, those are business returns.
Yes, you used your business card to pay for the travel, right?
Yeah, but I wouldn't put a personal expense on a business return.
But you used a business card to pay for
everything.
I use
personal travel.
I use a business card to pay for everything, and what I do is turn over the statement to the accountant, and the accountant then says, "Okay, this expense that's personal. We'll put that over here. This expense that's business. We'll put that over here," and they reconcile it. So you wouldn't find a reimbursement from Ms. Willis on a business return.
Okay, so they're not anywhere there.
Nor would you find. Well, go ahead.
No, I'm just asking. So there's nowhere for any of that cash to be reconciled there, right?
On the business returns, no, ma'am.
Okay. We talked a lot about the financial affidavits. I know the state asked you a couple questions about them. You filed one in 2022. In that one, you stated that you only had $5,000 in cash, correct?
I believe you. Yes, ma'am.
That was sworn under oath?
At the time of the filing, yes, ma'am.
Okay. And then in January of 2024, you filed another one that also swore that you only had $5,000 in cash, correct?
At the time of the filing, yes, ma'am.
Okay. So in 2022 and 2024, you only had $5,000 in cash?
At that time, yes, ma'am.
At that time? I'm sorry, excuse me.
And then you also, all of those interrogatories, I'm not going to go through them in painstaking detail, but every single interrogatory you filed, there are 4 of them, all verified ones. Every single one, you said you didn't have any cash stored in a safe, a safety deposit box, or any other location. Plaintiff rarely carries cash. If plaintiff does carry cash, it's a nominal amount, correct?
That's correct.
Okay. So we've got what? 2021, you said you don't have cash. 2023, you said you don't have cash. Again in 2023, you said you don't have cash. And then in 2024, you don't have cash, right?
So you're assuming that I received the cash and I stored it. I received the cash and I saved it.
Well, you didn't put it in the bank, right?
What's wrong with receiving the cash, Ms. Merchant, and spending it?
Nothing's wrong with it, but
So
you didn't
then
put it in the bank.
that would contemplate why the response is what it is on the interrogatories.
So you spent the cash. That's because before, when it was asked, you said you didn't want to disclose where the cash was.
No.
Privacy.
No. Well, I said that if I were to store cash in my home, then why would I share that with the world, is what I said. I didn't say that I had some cash stored up in some place, because that's not the truth.
And you've talked a lot about this, I split with a third, I split with half. From the check you received from Fulton County, July 15th, 2022. So all the way back for July 2022, not a single check that you've received from Fulton County has gone into a joint banking account. Every single check has gone into your own personal banking account, correct?
All of them, with the exception of the checks that were going into the WBC firm, went into my business bank account, which is solely in my name.
Right, your WBC account that you're talking about, that account was closed, though, in June of 2022.
Correct.
So everything after June of 2022 was put in a Nathan Wade bank account, not a corporate bank account with partners.
I think the question right before that only needed a yes or no.
So no, ma'am. The checks were deposited into firm accounts, law firm accounts.
Law firm of Nathan Wade PC.
Yes, ma'am.
As a solo practitioner.
Yes, ma'am.
Okay, so they were not deposited into accounts with Campbell or Bradley.
No, ma'am, they were not.
Thank you.
However, there were checks written to Campbell and Bradley that will reflect the third.
And we've tried to get those bank records, but you've objected to those, correct?
You've tried to get what bank records?
We subpoenaed bank records, and you've objected to all of those, right?
Your Honor, I'm going to object to their relevance.
It's relevant if he's saying he has all these records, but yet we've tried to get them, and he's trying to keep them from us, but he doesn't bring all of the records. And you can make an inference if there's law that says you can make an inference if some documents are within the party's control and they won't provide them, that there's an inference that they're not positive.
That's correct.
There was no obligation for Mr. Wade to produce evidence that Ms. Merchant couldn't find an admissible way to produce. I believe it's irrelevant. We've covered the ground, and I object to any further questioning.
All right, I'll sustain that. Ms. Merchant, let's find some new ground here.
Okay, thank you. Are you willing to waive your privilege with Mr. Bradley so that he can testify?
I am not willing to waive attorney-client privilege.
Okay, thank you.
Only on the questions, the health questions that were asked on campus. And I can ask it from here because it's very short. I don't want to get into the type of cancer. I don't want to get into the medical condition itself. Did I understand you to say that you had cancer in the year of 2020?
Yes, sir.
And you explained that because of that, in 2020, you were or kept yourself in a sterile environment?
I tried, yes, sir.
Now, what about 2021?
2021, just focusing on my health, trying to get back to myself.
Remember I asked you some questions about Hateville?
Yes, sir.
And the condo?
Yes, sir.
And you indicated that prior to November 1st of 2021, you had spent time at the condo, the Hateville condo?
Yes, sir.
With Miss Willis, right?
Yes, sir.
And with someone else? You said Miss Yerdey?
Miss Yerdey, yes, sir.
Okay, so you were not concerned, that was not a sterile environment, was it?
Are you inferring that Miss Yerdey and D.A. Willis is not sterile? Of course it's a sterile environment. It's a condo.
But don't you remember then I followed up and said, where else might you have been to show your cell phone records from Hateville? And you said, the airport, right? Not a sterile environment, though, the airport, you agree?
It is not.
Okay, what about restaurants? Not a sterile environment, right?
They are not.
And the Porsche, you said something about a Porsche what?
Porsche experience.
That doesn't sound very sterile to me. Is that a sterile environment?
You're inside of your vehicle.
Yeah, but don't you mingle with others?
You can.
Yeah, and you were doing all that in 2021 before November 1st. That's what you testified to, correct?
Yes, sir.
So there's no reason why you couldn't be dating in 2021, is there?
You mean 2020, Mr. Sadow?
No, I said 2021.
All right.
Correct?
Dating? No.
No reason.
No reason.
Got it. Thanks.
All right, Mr. Gillen? Okay. Mr. Stockton, excuse me.
Just real briefly, you said you started dating early 2022, and you also used the term personal relationship. And there was no dating and no personal relationship prior to early 22. Is that correct?
Help me understand. I want to make sure I answer you. So let's be clear. 2022 was the start of any intimate sexual relationship with a district attorney.
Okay, and that's what I was wanting to
Okay.
make clear. In your affidavit, you used the term personal relationship.
Got it.
Today, you've used the term dating. And your testimony today is that includes the term basically physical or sexual or intimate relationship. Is that correct?
Yes, sir.
And there was nothing, according to your testimony, there was none of that prior to early 2020.
That is correct.
That's all I've got, Judge.
All right, not seeing anyone else. Ms. Cross, any redirect? All right, Ms. Merchant, can this witness be excused?
Judge, we asked to keep him under subpoena. We might need him to come back after the subpoena.
All right. All right, you may step down, Mr. Wade, and please don't discuss your testimony with any other witnesses.
She mentioned subpoena, Judge. Let me just say this. That was an inference made that I was somehow evading service of a subpoena.
We can take that up. I don't think we need to have that on the record in this hearing. Understood, Bill.
Thank you.
All right, Ms. Merchant, any other witnesses?
Yes, we would call Fani Willis.
All right, Ms. Cross.
Your Honor, I am going to eject and remove to the...
Okay, I am going to... I'm going to pause it here. I've been live streaming for about 3 hours and 32 minutes, so I'm going to come back with this later when they cross-examine Fani Willis. I have to say his testimony was very eye-opening. At first, I thought he was like real slick, but now I understand why he answered the way he did. He tried to keep his divorce and his criminal trial separate. I get that, and he didn't get paid a lot of the money that he should have received, but for some reason didn't. So he's not the slippery snake that he was made out to be. He's been through a lot. But on that note, I want to thank you all for sticking here with me. And please, if you want to, Cash App, Venmo, PayPal, Politics with Laura, any and everything would be greatly appreciated. Any dollar amount, greatly appreciated. And thank you for sticking with me on that note. Bye-bye.